again, second, you need to understand that to procure an argument of breach of data privacy, you need to look at three different parts. The very first part, Your Lordship, being the collection of such data, the second part being the processing of such data, and the third part being the sharing of such data without consent. And that is what I'm going to be dealing with in issue 1. And my Lordships, by the time I'm done with issue 1, I would have also solved 85% of issue 2. I beg to proceed. Moving on, the very first thing you need to understand that data itself, in the very first instance, was collected without consent, and the applicants don't actually say anything to that. But where we have a problem with consent is the second collection of such data that was procured by Infinity Analytics from Your Life app, and also the sharing of data from between BrainBook and Infinity Analytics app. When I get another point of quotation I have before the Honorable Court is that for a person to collect data or data collector, they must be certified under the Data Protection and Privacy Act. That did not happen with BrainBook Incorporation.
Counsel, the issue you framed concerns the sale. So I would request that in the interest of time you stick to the issue of sale.
Much obliged, my Lordship. Yes, much obliged, my Lordship. So I will proceed with that. The second sale of such data was procured without the consent of the data subjects. The Act clearly defines, when talking about consent, that consent should be clear and unambiguous. So,
yes.
What section of the Act?
Section 2 of the Act that defines consent. I'll read for you verbatim if you don't mind, Your Lordship.
Just paraphrase.
Oh, all right. With paraphrasing, consent should be gotten unambiguous. It should be freely expressed and gotten from the data subjects directly. That takes us to section 11. Section 11 of the Data Privacy and Protection Act is to the effect that data shall be collected directly from the data subject. That was not procured, that did not happen, where Infinity Analytics gets data not from the subject, but from Your Life app, but from BrainBook app. That, my Lordship, is the absence of consent. Consent is a very strong thing that's actually brought out in section 7.
Counsel, have you addressed your mind to the exceptions under section 11.2?
But yes, Your Lordship.
What do the exceptions say?
There are very many exceptions, Your Lordship.
Such as?
One of them is data could not be gotten directly from the data subject, where it was not practicable to get such consent.
Counsel, have you read the contents of section 11?
Yes, Your Lordship.
And the exceptions state what, sir?
Your Lordship, the exceptions under section 11 are up to paragraph G. There are very many.
So don't you think in this context, the information actually does fall under one of those exceptions?
I do not think that, Your Lordship.
Why do you not think so?
Why I don't think so is that the very first exception is that the data should be contained in a public record. This data was not contained in a public record, it was rather in a private record. Why? Because people had to sign up and give in their passwords. Among this exception, a public record is data that has been put out, like the Uganda Bureau of Statistics, data that's going to be accessed by anyone of the public when they want to access it. That is not the case right now. Right now, you cannot access this data. I cannot access any of my clients' data if I don't have their username or password. That falls short of the requirement of public record. But the other exception talks about that the data has... Oh, I was going to look at all the exceptions and show how none of their cases fall within that. Moving on, the second part that shows that the second necessity is that data should be collected for the same reason as to why, data should be processed for the same reason as to why it was collected. Particularly section 17 of the Data Protection and Privacy Act. This was breached as according to the facts. Professor Owang processed this data in a psychometric model. A psychometric model procession was to the effect that such data can be later on sold for commercial purposes. What do I mean, my Lordship? If you go to any of my clients, 120 people, and ask them, when you filled in this survey, what did you see? They will tell you that they only give you their opinions about gambling. None of them at any one point saw them helping another firm to do market research. Why? Because if you look at the app, if you look at the instant
Counsel, are you saying that in principle it's illegal to use? Counsel, are you busy?
Pardon me, Lordship.
Are you too busy for this court, counsel?
No.
But you're well aware you're coming for a court session. Maybe that's what you're looking for.
Apologize for that, Your Lordship.
So, is it your view that in principle, the psychometric model does not fit within the requirements of the Act and that it's illegal?
Yes, it is my view, and as why I would say it is my view is because the requirement of the Act under Section 17 says that data should be processed for the further processing of data should be in line with the original reason as to why data was procured. The original reason as why it was procured, it was for academic research. But the processing in the psychometric model was fitting the wants of Infinity Analytics, because at the very beginning, Infinity wants to make an app known as Yomola. That is going to rival other mobile money products. So a psychometric model helps them create such market research data that will help them do such an app. And the mere fact that such sharing of data was monetized, it makes it for commercial purposes and outside education purposes. So none of the subjects could really have seen the data.
The question is simple, that in principle,
yes, Your Lordship.
this court declare that it is illegal for any data collector to use a psychometric model?
No, Your
Simple
Lordship.
as that.
In principle,
Yes.
that would be a two-way argument. It would be illegal. It is legal to use a psychometric model if it is matching with the same reason as why you collect such data. But at the moment you use psychometric model in a reason that is different from the reason why you collect it, then it's illegal in principle under Section 17, Your Lordship. Much obliged, my Lord. Wrapping up with issue 1, the other part I want to talk about is, I already talked about absence of consent. That's what I want to stress about mostly. You see, when data was being shared between your life and Infinity Analytics, there was no consent from the data subjects for sharing such data. Section 13 of the Data Protection and Privacy Act is to the effect that Section 13 is to the effect that information has to be certain information. Section 13 subsection 1 gives out information that should be given to a data subject before you collect such data, which includes the name, the address, and everything of the sort. I would have talked about Brainbook having no address, but I was stopped from doing that by Your Lordship, so I will not talk about that. What I'll talk about is that there's an exception to that. And the exception is that if data is to be procured by third parties, that is under Section 13 subsection 2. If it's to be procured by third parties, Your Lordship, then the information in subsection 1 should be reprovided back to the subjects. And under Section 13 subsection 1, part of the information is the reason as why you're collecting your name and address. It's basically talking about consent. Consent is an issue that we need. I would like Your Lordship to look at the issue of consent as something that is actually very important.
In this application, is your challenge that they should never have sold this data, or that they should never have sold this data without consent?
My challenge, first of all, is that they should never have shared data without consent. But then again, secondly, they sold data, which is illegal under Section 37 of the Data Protection and Privacy Act. It is a two-way challenge, Your Lordship, because the issue says whether the sale was lawful. Before this honorable court, I would like to establish, based on Section 37, not on my own authority, that first of all, sale is unlawful. But even if there's a situation where a sale could be lawful, there's absence of consent.
But counsel, if Section 37 is clear that sale is unlawful, which other instances can the sale be argued to be lawful?
There's no other instance, Your Lordship.
So why are you arguing this?
The reason that's why I'm arguing this is because our main cause of action before the honorable court is that breach the right of privacy. If I show how sale itself is illegal, but then I fail to show that there was breach of privacy, meaning my clients will not get entitled to the remedies they have.
I think these are two different issues, and I think you stand a risk of confusing this court if you keep relating these two issues, which are clearly distinct, counsel. Section 37 is clear. I wonder why you are belaboring on an issue that is actually very, very clear, counsel.
Much obliged, Your Lordship. Thank you for that, Your Lordship. Moving on, I would like to invite the honorable court to look at the case of Basaja Balaba Yakub versus MTN Uganda Limited. In this case,
That's the full citation of the case. Could give us the full citation of the case
And the facts of the case, briefly.
Your Lordship, I've misplaced where the full citation is. I have a brief, but I can give the facts of the case if Your Lordship
how can we
wishes.
find it?
For the record, counsel.
Would prefer that you cite the case whose full citation you know and whose facts you know.
Yes, Your Lordship. Alright, the facts of this case was Masaja Balaba.
Counsel,
Yes.
if you are unable to provide the citation, cite a case whose citation you can provide and give us the facts.
Yes, Your Lordship. Alright, moving on to issue number 2, whether the parties are compliant with the existing legal regime, regulatory regime. Your Lordship, we should note that the current regulatory regime we have before us is the Data Protection and Privacy Act. The other regime we have before us is the Constitutional Republic of Uganda. And the other regime we have before us is the National the Data Protection and Privacy Act and the Constitutional Republic of Uganda. That's what I will basically face my arguments. As already said, as already discussed in issue 1, the reasons why we think the parties are not compliant with the regime are very simple. The very first reason as to why it is because data was collected in a manner that infringes on the privacy of the data subjects. This is because consent was not procured. Section 10 says that data should not be collected. Section 10 of the Data Privacy and Protection Act says that data should not be collected in a manner that infringes on the privacy of the data subject. And as already proven, the respondents breached that. Yes, in the first instance, but not in the second instance, Your Lordship.
So if
And-
the submission comes that this data was collected twice from the subject.
Your Lordship, it was my submission at the start of my issue saying that data was collected in 2 different phases. And I said we don't contend with the first collection, but we contend with the second collection done by Infinity Analytics from Your Life app, Your Lordship. Much obliged, Your Lordship. Moving on, there was unlawful processing of such personal data by Professor Owang specifically for commercial purposes, which differs from the original reason of collection that was academic research. Moving on, there was a gross violation of
But are we certain that this is the kind of data that had all those requirements under the Act? Is this really personal data in view of the facts?
yes, much of
From your own submission, this was data collected for a psychometric model.
yes,
It's just genuine information.
much obliged, my Lordship.
I would prefer that you first listen to the question.
Right.
This is really just genuine information about the person. And so, how certain are we that it fits within the meaning of personal data under the Act?
Much obliged, my Lordship. For purposes of precision and accuracy, I would want to read what personal data is under the interpretation. Personal data means information about a person from which the person can be identified. I will stop there. I won't go any further. Personal data is data that is unique to a person, whereby if they get that data, they can identify who this person is. But how am I relating this to the data that was collected?
Take us to the facts.
Yes, taking us to the facts. I'll read them off it. Taking us to the facts. Data was collected.
Paragraph.
Okay.
Not very ideal.
Paragraph 5, Your Lordship. Paragraph 5 stated that data was collected. Okay, let me read for you. Paragraph 5 says that Professor Owang, for his research project on consumer preferences, designed a questionnaire and conducted a survey using the Brain Book platform to understand personality traits and collected information from various stakeholders. One of the data, some of the data that was collected by Professor Owang falls. Oh, much obliged. Data that was collected by Professor Owang falls within the metric of special personal data. Special personal data is data that identifies someone, for example, their political affiliations and their financial spending habits.
And that's according to what legal authority?
That is according to Section 9 of the Data Protection and Privacy Act that talks about special personal data. So, data that relates to someone's religious affiliations, political affiliations, and financial spending habits falls within the ambit of special personal data. And as all defined personal data was defined by data that can be used to identify someone that is special to that person. So someone's political affiliation, someone's financial spending habits are special to them and fall within the ambit of special personal data and also fall within the ambit of personal data, Your Lordship. With that, I would beg to yield ground to my co-counsel who will substantiate on issue 3, issue 3 and issue 4, and will make the appropriate prayers for our clients. Much obliged, Your Lordship.
Thank you, counsel. It's always respectful to wait for your time to sit before you rise. Which also means that counsel should speed up.
Much obliged, Your Lordship.
To bless my Lord. I pray this court is priest. My name is Sylvie Ernest, and I'm counsel for the applicants. I'll handle issue 3 and 4, and I'm going to start with issue number 3. Time, I'll use 10 minutes, as earlier stated by my colleague. Issue 3 states whether the applicant is entitled to obtain the NOIC pharmacal order that they seek for. And actually, we are the applicants that are seeking for that order. Much obliged. The NOIC pharmacal order was defined in the old case of...
What's your answer to the issue?
My answer is we are really... we deserve to be granted that NOIC pharmacal order.
You who?
The applicants, my lord. The NOIC pharmacal order was defined in the old case of NOIC Pharmacal Company versus Customs and Excise Commission. It's a 1974 case. In this case, they held that
Can you get the full citation?
it's NOIC Pharmacal Order versus Customs and Excise Commissioner, 1974.
Before what court?
My lord, I
Give us
beg
the full citation and the court.
much obliged. It's NOIC Pharmacal Company versus Customs and Excise Commissioner, 1974. SC 1033. It was held
AC meaning?
Appeals Committee. Appeals Court. Appeals Court.
How's the issue? You seem a big shake.
You wish to retract that statement?
Yes, my lord, I wish to retract that statement and
What does exist stand for?
I beg to consult counsel.
Thank you, consult counsel. This case was held in 1974, and the act in question that you have over there, I think, came into force in 2019. Has this court, by any chance, made any decisions in regards to that particular case?
Yes, my lord. Much obliged. It was held, this same issue was handled in the case of DFCU Bank versus MTN and others. Messiah's application. It was in the High Court before Justice Mr. Sekana.
Okay, give us the brief facts and then proceed.
The brief facts in this case, MTN, Airtel, and Afcel applied to court that GFCU had leaked information of their clients as they are sending messages. So in this context, they applied to court so that they are given such orders to check on the actions of the defendant, my lord.
What information was sought by the applicant in that case?
Yes, in this case, if someone is opening up an account, they give their personal data, which becomes user data. So in this context, it was linked with the mobile telecoms in order to ease communications as your bank.
Counsel, the question is very simple. Which information did the applicants in that case seek?
My lord, I beg to pardon me, question.
In the case you have cited,
Yes,
DFC versus MTS, decided by this very court, guide us on what information exactly was sought by the applicants in that case. Who are the applicants in that case?
The applicants, DFCU Bank.
Yes. So what information did they seek in that case?
They are seeking.
And counsel, was the order granted in that case?
The order in that case.
Before we get to the order, what information?
It was personal data, my lord.
Which personal data?
Personal data of the client.
Which one?
Like?
Did you read the case?
I read the case.
If you read the case, you know that principle of faith
Yeah.
and and you know which data.
You can also yield to self-code stamp and proceed to the holding.
My lord, I'll beg to proceed with the holding in this case.
So you yield.
So you have decided to ignore our question.
Not necessarily ignoring legal question, but in fear of errors in law and misquoting law.
But if you read counsel, how do you misquote the law?
Okay, primarily, okay, thank you very much.
The reality is it's not wise for you to proceed. Because in my mind, I'm still worried. What was the information?
The information primarily, their telephone numbers, my lord.
Are you certain?
Personal data cannot be just telephone numbers, and that verifies it's more than just telephone.
Yes, as going back to my earlier submission, as I stated, these clients were seeking for personal data, and this personal data included telephone numbers, their names, and nationalities.
So in this application that you're now making, what information do you see?
In this application, as in regards to the facts, my clients applied their nationalities, their religious affiliations, political affiliations, and their spending habits, my lord. And
so they want the respondents to tell them their nationalities. I want to be certain.
Yes,
If we are to issue this knowledge pharmaco order, which you see, what information should it be discovering?
Much obliged, my lord. In this context, we are
What do
seeking.
you want to know?
Yes, we are seeking this order to check on how your life ascertained the data that is sold to Infinity Analytics, whether it really are abided by all the legal requirements.
What are those legal requirements?
Legal requirements are stated under Section 3 of the Data Privacy and Protection Act.
The legal requirements for obtaining the order or the legal requirements?
The legal requirements that they have ascertained before they get people's data. Yes.
Same as to those legal requirements.
Much obliged. Section 3, it states the principles of data protection. The data protector must be accountable. The data collected and processed, it must be collected and processed fairly. Data collect, process, use or hold adequate, relevant, not excessive or unnecessarily personal data.
So in this particular case, in view of those principles, you want to know whether they adhere to accountability?
Not really, my lord. In this regard, we are asking, for example, when our clients gave in their data, it was primarily for academic purposes, and it's a principle that such information should be kept for a reasonable period of time. So it's my submission, my lord, that this data, if academic purposes had got done as it was the main principle, it was prudent for the respondents to erase such data. Much obliged, my lord.
Counsel, in relation to the agreement, was it stated somewhere that even after them giving their personal data, it should be for a specific period of time?
My lord.
Secondly, you seem to be seeking for the knowledge pharmaco order, but is there any other remedy that you can ask this court to give you in case the knowledge pharmaco order is not possible, or it may take long? Any other remedy you could?
Yes, primarily, Section 98 of the Civil Procedure Act gives this court coherent jurisdiction to grant orders. And such orders, in this context, we shall ask for discovery of documents under Section 64 of the Evidence Act. This was stated in the case of Karhanga and another versus the Attorney General and two others, in which it was stated, if I can read verbatim, it was a miscellaneous cause number 0060 of 2015, in which it was said that discovery is contingent against a party's reasonable belief that he or she has a good cause of action or defense. In this regard, my lord, it's my submission that in regards
the requirements for discovery different from the requirements of an NPO.
Primarily, I was answering the question of
Yes,
my
now
lord
we
when he
want to
stated
know.
that any other remedies that we would seek in Ugandan jurisdiction, my lord.
But please answer the question.
Yeah, the question is, again, very simple. Are the requirements of discovery under the law different from the requirements of an NPO under the law? Guide us on the two.
Primarily, when you're seeking for discovery, it's in most cases in terms of private documents. So in this context,
In most cases,
okay, much obliged, my lord. In this context, in terms of discovery, we shall seek for much obliged. I humbly ask for 2 minutes to sum up my submission.
And then you'll have an extra minute to summarize issue 4.
Much obliged, my lord. In this context, we ask for discovery in terms of private documents. So in this context, we are before this court, as much as the fact that this private data and the private documents in this context, we ask for court to grant our people the discovery order, which differs from no Pharmaco order, because the no Pharmaco order, it's mainly if someone has a reasonable cause of action. So they seek this order to be granted access to information. So they might see, they are different in one or another, but as His Lordship has asked me, it was prudent for me to give him any other remedies that he would seek for.
if you could briefly just bullet the 3 conditions.
The 3 conditions under the non-economic order: 1, a good arguable case; 2, the defendant must be mixed up or facilitated the wrongdoing; 3, likeliness to provide such information, and of which the respondents can
Beautiful. So
provide that.
in the case that you cited of DFCU versus MTN and the like, was the order given as the justice asked?
In this regard, the order was not granted under DFCU versus DFCU Bank versus MTN on basis that Justice Sekana stated in his judgment that it wouldn't be prudent to give out such data in case all parties to the case have not consented to this. So my reason for bringing up this case.
Right there, counsel. If I'm not mistaken, over 1 million people gave that data. You have 120 people as your clients.
Exactly, that's
Why then should we give you consent, yet you don't even have 50%?
Primarily, I brought in this case to try and define how no economic order was attempted to be applied in the Ugandan jurisdiction. So the case wasn't binding, but rather I was persuading in court, my lord.
The case is not binding.
It's binding, but I was trying to persuade court in relation to the facts, because facts are kindly related.
Is there any other case in the Ugandan jurisdiction in which this court granted the NPO?
My lord, in my research and reading, I realized there are some cases, like for example, Mwema versus Facebook, Ireland, but though it's not, it was held on a foreign land, that was Ireland, hence making not a Ugandan case, but specifically it's DFCU Bank versus MTN that I got in my research, my lord.
Proceed.
In 1 minute, issue 4.
Much obliged. I'll proceed with issue 4, whether the applicant is entitled to the remedies sought. My lord, we ask for injunctions. As much as the fact that our client's data is in process for this long.
How many?
Pardon me, my lord.
You said you're asking for injunctions. I'm asking how many injunctions?
Injunctions, I'm asking for an injunction to the respondents. Yes, Section 38 of the Judicature Act gives this court authority to grant such injunctions and to grant injunctions to deter the respondents from a continuous wrongdoing.
How many injunctions are you asking?
Injunction, primarily I'm asking for.
You can put a name to it.
What type of injunction are you asking?
I'm seeking for.
Are there different types of injunctions, or there's just one type?
There are different forms of injunctions.
So which
There
one do you want?
in this, there are interim injunctions. There.
Which one do you
Which
want?
one do you want?
We're asking for interim injunctions, my lord.
Interim.
Pending what? Interim, pending what?
Pending the judgment, as court will issue judgment.
Okay.
Yes, I'll proceed in the case of Kagu.
You don't have to. Any other remedies?
Any other remedies would seek for compensation under Section 33 of the Data Protection Act and Section 27 of the Computer Misuse Act. Specifically, we shall seek for general damages and exemplary damages.
And you're also seeking compensation under Article 50 of the Constitution.
Much obliged, my lord.
Why are you proceeding under Section 33 of the Data Protection and Privacy Act and not under Article 50 of the Constitution to seek for that compensation?
As earlier stated by my colleague, he stated the jurisdiction of this court, and he stated Article 50. I do beg.
I think you're misunderstanding the question. Why do you seek your compensation under Section 33 and not under Article 50?
Yes,
are you seeking under both?
I'm seeking my compensation under Section 33 because it's the immediate law that we are approaching in data protection, my lord.
How about Article 50? Why not under Article 50?
I addressed myself primarily on Article 33 because it's an immediate law that supervises this court in this application, my lord.
Counsel, I heard you talk about the Computer Misuse Act.
Yes, my lord.
Which particular provision?
It's Section 27 of the Computer Misuse Act.
What does it state? And why do you need it in relation to this particular point? Just in a section.
Much obliged.
Because it's one thing to cite something, but it's another for it to be relevant.
In this regard, we're asking for this under Section 27 of the Computer Misuse Act. It states that if someone has misused data or a computer in one way or another, they would come to court to seek compensation in regard to the misuse or the wrongful act. Yes, I'll proceed in this regard.
Counsel, you don't have much time.
Yes, I'll paraphrase.
The other remedies, if any.
Yes, general damages. This was backed up in the case of El Talem.
Other remedies.
I will seek for and also exemplary damages to deter the respondents from doing such act, and they act as an example. And we pray this court that the respondents suffer costs for this suit and any other remedies that this court might deem fit. Much obliged, my lord.
Thank you, counsel.
Yes, my lords.
Proceed.
Much obliged, my lords. My lords, appearing for the respondents, I am Dalton Chisule, together with Tracy Naiga and Sarah Crescentia Nachia. My lords, I'll be responding to issues 1 and 2 and raising preliminary objections before your lordship. I'll be using 20 minutes of this honorable court's time, and my co-counsel, I'll be addressing you on issues 3 and 4 shall use 10 minutes of this honorable court's time. We shall also exercise our right to rejoinder, my lord. Yes, my lord. My lords, the brief facts as known by the respondents are that Infinity Analytics, a data consultancy.
Unless you want to make any clarification as to their statement of facts, simply proceed to the legal arguments.
Much obliged, my lord.
You want to make any clarification?
Indeed, my lord.
Point that out.
Particularly, the applicants omitted to bring it to your attention that Infinity Analytics, in its intention to expound the niche markets and develop digital innovation in this country, entered into a partnership with the university. Much obliged, my lords.
Is that all? As far as the clarifications are concerned?
My lords, I shall clarify more as I submit before your lordships.
Proceed.
Much obliged. My lords, your respondents raised a preliminary objection to this particular suit inasmuch as the applicants do not satisfy the pecuniary jurisdiction of this honorable court. My lords, your applicants, my lords, your respondents posit that the applicants have not satisfied the pecuniary jurisdiction of this court This court has unlimited original jurisdiction, but it is the position of the law that an act that expressly ousts the jurisdiction of this honorable court shall have matters handled first in it, and that was the holding of the Supreme Court in the case of Rubble Enterprises versus Uganda Revenue Authority. My lords, it appears, as seen in Section 33 of the Data Privacy and Protection Act, that a party aggrieved by the actions of a controller, collector, or processor shall appeal to a court of competent jurisdiction for compensation. Unfortunately, the Data Protection and Privacy Act does not clarify what a court of competent jurisdiction is. Fortunately, my lords, the Human Rights Enforcement Act, as seen in Section 4, subsection 1D, posits that the High Court shall try all matters pertaining enforcement of rights, provided they are far above the pecuniary jurisdiction.
I think maybe when you are running circles, why don't you proceed to your substantive arguments? Because you raise an order and you respond to it. I mean, an objection, then you respond to it. As the other side would have, I think you should just proceed to your substantive arguments.
Your objection is not.
Much obliged, my lord. May it please your lordship that I raise an additional objection.
Proceed.
My lords, the applicant's suit, Offence Order 1, Rule 8, as they proceed in a representative action without satisfying the requirements of this honorable of the civil procedure rules as amended.
That is also not.
Much obliged, my lords. Proceeding to the merits, as enunciated earlier, I shall be dealing with issues 1 and 2. Issue 1, which is whether the sale of data from Your Life to Infinity Analytics was unlawful. My lords, your applicants.
Answer to that issue.
Our answer, my lord, is that the sale was lawful. My lord, the applicant, my land, brother, the first speaker for the applicants. Much obliged, my lord. The first speaker for the applicants did bring it before this honorable court that this particular collection of data from Infinity Analytics was not direct collection in line with Section 11 of the Data Protection and Privacy Act. My lords, we contend that this particular collection falls within the exception in subsection 2B. My lords,
What is that?
my lords, subsection 2B of the Act reads that the data, notwithstanding subsection 1, personal data may be collected from another person, source, or public body where the data subject has deliberately made the data public. My lord, to answer this particular issue effectively, I would have to refer you to Section 13 of the Data Privacy and Protection Act, which enunciates some of the requirements needed for a person to fairly collect data, and among them is the identity of the collector, the purpose, and what type of data is required. My lords, referring you to the facts, particularly at paragraph 3, Infinity Analytics, in its particular desire to expound niche markets, enters into a partnership with the university. The university, my lords, as seen at paragraph 5, in its attempt to understand consumer preferences, does, through the professor or Wang, collect particular data pertaining these particular preferences through questionnaires, my lords. This particular data, through the psychometric mode of collection, reveals to the person submitting their data what type of data is collected, who is collecting it, and for what particular reasons. And suffice to say, my lords, as seen at paragraph 12 of the facts, Comrade Wagwez himself admits that the professor did approach him for data for research. To that end, my lords, it is our submission that this particular data was made public deliberately.
Does it matter that the data was personally protected?
Yes, my.
Okay. So, does that have any, because to make it public is to put it on a public platform which anyone can access.
Yes, my lord.
But now this was only accessible to your clients. This information was only accessible to your clients. It's not that they went to the newspapers and published for everyone to know.
Yes, my
This
lord.
information was collected by a particular person.
Yes,
So
my lord.
within the meaning of that provision which you read, was the information really made public?
Yes, my lords. Our contention is that this particular data was made public, provided that a person who desires to access this particular data can apply to get it, but then its grant has to be within the ambit of the law, and your respondents would then have to consider the
In
lawful
principle,
provisions.
what would you understand by making this data public? Is it to make it accessible to your client alone, or to make it accessible to the general public? What is your construction of that provision?
My lords, to make data public is to lay out data to the public.
Yes, not necessarily to disclose it to a third party. If you disclose it to one third party, as the applicants did,
Yes, my lord.
trusting that the third party is aware of the law and will observe the law,
Yes, my lord.
you can't necessarily say that that has to make their information public. They really didn't.
Yes, my lords. Our contention is that even the third party falls among the segment of the public. If the applicants had wanted us to erase, correct, or even give them back their data, we could have done so, but it does not appear anywhere from the facts that such an application was made for the grant of that particular data to the applicants, my lords.
Let's proceed to the cell.
Much
Because I'm more interested in that. It's what is in issue.
Yes,
Right?
my lords.
Yes.
Our
Council cited section 37. What's your response?
Our response is that the law is clear in section 37 that no person shall offer for sale any personal data. My lords, the qualification in that particular section is that data that is prohibited from sale is the personal data, my lords. When you go to section 2 of the Data Protection and Privacy Act, my lords, personal data is defined as information that could wholesomely lead to identification of an individual, my lords. My lords, when you go to the facts as seen at paragraph 5.
But I don't know which rule, which actual provision you're reading, or which rule of interpretation you're reading. Because that provision does not state anywhere that it must wholesomely identify. It simply says it should be able to identify. Not to wholesomely identify, which means something completely different. So I guide us to that construction.
My lords, I shall take your guidance and restate my statement that data to amount to personal data, it must every, as you said, my lords, identify that particular individual. But evidently from the fact, my lord.
But still, again, counsel, guide us on perhaps some structure of statutory interpretation, because the statute does not use the word every.
Yes, my lord.
It simply says identify.
Yes,
So
my
we
lord.
are wondering where you're getting all these extra words that sufficient, that conveniently favor you.
Much obliged, my lord. I was working on your indulgence. I'll read the particular provision verbatim to your lordships. It reads that personal data means information about a person from which the person can be identified. And thereafter it goes on to list.
Which principle of statutory interpretation do you want us to apply in reaching, in understanding what is meant by identifying a person?
My lord, I would prefer the literal principle of statutory interpretation to be applied by your lordships by using the natural meanings of these particular words used in this statute to reach to the conclusion that data or information must identify an individual for it to be personal.
And Council, even if I were to take you on that specific aspect, that specific goal of interpretation, Council, that section you're reading goes ahead to look at data instances that actually define what personal data is, and they talk about the education level, specifically under B, the education level or occupation of the person. And to take you back to the fact, specifically under paragraph 6, it appears that this data was collected on the basis of different professions, which in the interpretation of section 2B does appear to look at the aspect of it, the education level, occupation of the person. So, Council, within that context, don't you think that data that was collected around different professions, the personality, location, tastes and habits, does actually fall under the definition of personal data?
Yes, my lord.
So if you claim, if you accept, if you concede that aspect, don't you think that by virtue of section 37, indeed personal data was sold? And as you prepare to answer this, Council, I remind you that it is okay to concede on an aspect that is very clear from the facts, Council.
Much obliged, my lords, and I'll take your guidance, your lordship. And our contention, alternatively, is, my lord, that this court applies its inherent jurisdiction and apply to these particular facts the doctrine of severance, my lords, and dislocate from this particular data collection transaction the elements of illegality and leave that standing those components which are legal. Because, my lords, the essence of this particular collection is to boost innovation, is to boost technological advancement, and it is to boost the economy wholesomely altogether.
I don't see how you've answered that question. You just seem to be rotating around that question. So you could just answer, is the data that you collected, does it fit under section 37 in regards to personal data? Because your client collected data concerning financial habits, political affiliation, isn't it?
Yes, my lord.
So does it fit under section 37 in regards to personal data?
Much obliged, your lordship.
Just get straight to the point without, because your time is.
My lord, it does.
So do you concede?
So that's a concession, Council.
Unless you can prove to us otherwise.
Yes, my lords, it is a concession. And in the alternative, I invite your lordships to apply the common law doctrine of severance and sever from this particular transaction the illegal element of sale, because the particular processing, my lords, was in line with the legitimate interest. Even the transfer to Infinity Analytics was to boost the niche markets. Infinity Analytics.
It was in line with legitimate interest.
Yes, my lords.
So selling people's data is legitimate interest because you collected it for academic purposes. Later on, your client sold it.
And guide us with some precedent on that doctrine of severance.
Much obliged, my lords. In Simon and Johnson's.
First answer this question.
Much obliged, my lord. My lord. My lord, I beg your pardon.
Okay, briefly.
Yes, my lord.
Your client collected personal data.
Yes, my lord.
And you claim that was for academic purposes. I will still take you back to this question. I don't know the answer to this question. You answered it. Now you collected it for academic purposes. Later on, you sold it.
Yes, my lord.
So does that fit in what you say in relation to legitimate interest?
Yes, my lord. My argument for that is that under the data protection and privacy regulations, legitimate interest is defined at Regulation 4 as that particular further processing that could be reasonably expected by a data subject. My lord, at paragraph 6, if this particular data was collected specifically for research and then, unfortunately though, sold to Infinity Analytics, but still to research the niche markets and develop your mula, my lord, that falls within research and analysis, because Infinity Analytics is actually a data consultant.
So does it fall under legitimate interest that you sold personal data?
My lord, that particular component does not, and we invite your lordship to survey it and bring into conformity the remaining transaction, my lord.
I am interested in your
Yeah, yeah, because you seem to keep going back and forth, then you bring the regulations, then you do this. So tell us more about
Much obliged, my lord. The doctrine of severance is a common law doctrine where the courts, when it comes to transactions that are partly lawful and partly void, the court can sever from that transaction the illegal bid, provided it does not go to the root of the particular.
So guide us with some precedent on this.
Much obliged, my lord. I refer you to the Australian case in Brooks versus Barnes, Philip, trustee, reported that.
What's the citation? What was the
Much,
Yes, and which principle? Just briefly, because you have 2 minutes left.
much obliged, my lord. It was reported that Australian High Court law reports at page 432 in 1969. I said Brooks versus Barnes. Barnes Philip, trustee. Barnes Philip, trustee.
At page?
Reported at page 432, my lords.
By which court?
The Australian High Court.
Decisions of the Australian High Court relevant before the High Court of Uganda?
My lords, they are persuasive in nature and non-binding on your lordships.
Under what law can we consider them given? We want to be sure that it's possible for us to consider such a decision.
My lords, you could consider them through the Judicature Act, section 13 and 14 of that particular legislation.
Okay.
Much obliged, my lords.
Following your doctrine on severance, I want you to specify to this court what exactly you want us to sever.
In view of that decision.
Much obliged, my lords. I invite your lordship to sever the component of sale, to order, to give an order redoing or undoing the particular sale and rendering that particular sale, in as much as it is contingent to the data or attached to the data, unlawful. This would be by way of a refund to the purported no, my lord. It could be by way of a refund of the particular amount to the buyer of the data.
But in this very case, that buyer has already had advantage of this information.
And the client's right to privacy has been breached.
Once information is disclosed, it cannot be undisclosed. So even if us cancelling this transaction means that there is no way that works out of this clean. They've already had advantage of this information. Even if we say let them destroy the information, they've already seen it.
Much obliged, my lord. An order could emanate from this particular court, ordering the rectification, the destruction.
Can we order that they forget this information out of their mind? They delete it out of their mind because they've already seen it.
My lord.
In my view, conceding on this, I don't know how we can even survive. Because from their mind, the information is already there. Even if they've stored it in whichever storage device, and the damage has been done already.
Much obliged, my lord. My lord, the right to privacy, as enunciated in the general comment on Article 17 of the ICCPR, is that privacy entails, in the modern age, it entails the traditional right, it entails data protection, and at the utmost, it also comes with the right to be left alone or forgotten. My lord, in destroying this particular data, all components, all aspects on this particular data shall be actually eliminated from existence. I invite your lordships to derive persuasion.
The traditional sense of privacy, but we no longer live in the traditional times. We now have social media, and these people's data was stored in a certain place.
Yes, my lord.
And then it was sold without their consent.
Yes, my lord.
So even if we were to destroy their data, still, I mean,
the deed is done.
yeah. And now with software coming into it, seeps into right to privacy. So you cannot really argue that in the traditional sense you can sever and destroy. You get what I mean?
My lord, if my understanding...
Just answer the question, because your time is fast spent. Answer the question and we'll conclude.
My lord, my understanding of the right to the privacy traditionally is that personal space, non-intrusion of premises, and then in the...
So if someone were to hack into your bank account details and was able to see your balance, or was able to see your messages on Instagram and Facebook, would that be a violation of your right to privacy?
It would, my lord, and it would also equally fall in the data protection.
So you wish to retract your earlier statements?
My lord.
You've forgotten your earlier statement.
Not really, my lord.
Okay, in 1 minute.
Yes, my lord.
Sum up what you have said. Sum up what you have said on issue 2 and then you can answer.
Much obliged, my lord. My summing up specifically on issue 2, which is whether the respondents were compliant.
Sum up on issue 1. What have you said?
On issue 1, my lords, my arguments have been that this particular transaction was in line with the exception in section 11, subsection 2b, and this particular further transaction or further processing Infinity Analytics was in line with the section 12 read together with section 17 of the Act and regulation 12, my lords.
On issue 2?
On issue 2, my lords, which is whether the respondents were compliant with the regulatory framework, my lords. It is our submission, briefly, that the respondent professor in his collection of data through the Brain Book was acting as an agent for the university, which is actually a registered collector and processor. Infinity Analytics, to this end, my lord, was acting as a data recipient in line with the Act, who is not required to actually undergo registration with the Personal Data and Protection Office. My lords, if I'm of no further indulgence, I'll yield the floor to my co-counsel.
Much obliged, your lordships. As earlier introduced, my name is Naiga Tracy, second counsel for the respondents, and I shall handle the third and fourth issue in 10 minutes. Your lordships, the third issue is whether the applicant is entitled to the no-wish pharmacal order that they seek from this court. It is the respondent's position that the applicant should not be granted this order for failure to prove that they need this particular order for what they are alleging they need it for, and also for failure to prove the elements that they have listed. Much obliged, your lordship. Under paragraph 13 of the facts, the applicants allege that they need the order to obtain information from the data used in the development of their life. Your lordships, this has not been proven by the second counsel for the applicants. Your lordships, I would like to first drive you back to the case cited by my land brother, DFCU Bank Limited versus MTN Uganda Limited and others. Miscellaneous application number 640 of 2019. Your lordships, I would like to point out the fact that my land brother has erred in the facts of what happened in this case. In this particular case, your lordships, the matter concerned a propagation of fake news by the defendants. Your Lordships, in this case, one of the parties, DFCU Bank, had bought parts of Crane Bank. So one of the people of Crane Bank paid some people to propagate false news, and those news were later on given out to other people through his WhatsApp number. And that is how MTN, Airtel, and Africell come in, because they were the means through which he was distributing this information. Your Lordships, in that particular case, Justice Musa Sekana highlighted one of the things that need to be in place for this court to grant the no-wish pharmaco order. That is that the applicant should not be ambiguous in the data that they require. Your Lordships.
So is that decision binding on this court, or we can depart?
Much obliged, Your Lordship. That decision was in this very court by Honorable Justice Musa Sekana, and it is binding.
The question is very simple. Is it binding, or we can depart?
It is binding, Your Lordship.
So we can't depart.
The High Court cannot depart from its previous decision?
Much obliged, Your Lordship. The High Court can depart from its previous decision if the facts of the matter at hand are largely different from what was held previously.
So we can, in that case, they didn't grant the order, but in this case, we can't grant it.
If the applicants are able to prove that they actually need the order, which they have specifically failed to do so. Your Lordships, as I was saying, in this particular case, it was stated that the applicant has to be very specific of what they need. The applicant has proceeded under paragraph 13 again to show that they need information from the data used in the development of your lives. Now, the question that is raised upon reading that particular paragraph is what information? What are they going to use this information? That brings me to the purpose of this information. The earlier case that is cited, Norwich Pharmaco Company versus Excise and Customs Commissioners, 1973, the House of Lords of the UK highlighted that this order will be granted where the innocent third party holds information that is vital to the case. The applicants under paragraph 13 have ably failed to show that the information that was used in the development of your life is very paramount to their case, and failure to be granted this order will destroy their case. Your Lordships.
In the Norwich Pharmaco case, was the information sought vital to the case?
Much obliged, Your Lordship. The information was.
In what way?
This information concerned importers. There was a patent, and there were people that were importing using that patent. The Commissioner of Excise and Customs had the information regarding those persons, and the defendants needed that information to know who was working in their name first and foremost, and who was breaching the statutory requirements of the UK. And that is what...
But in this case too, lawyers have the information of everyone else to share the data with. Just like in that case, the Commissioner for Customs had information about all those inputs. So why shouldn't we use the same principle? Since your clients are the ones who share the information, we know, and we can, on the same breath, make a similar order.
Much obliged.
How does that case differ from our facts?
Unlike that case, in that case, the applicants ably proved that the Commissioner had the information, and this information was going to be used in their case. The applicants in this present case, from Grace and the 120 others, have failed to prove that there is even information that they require. They're just alleging...
Are you saying that there is no correlation between what they have sought and pursuing their claim for compensation? Because all they want is disclosure for who else you've shared this information with, so that they can better make their case, just like the Norwich Pharmaco Company sought. So are you saying there's no correlation between what they seek and their case, pursuing their claim?
Much obliged, Your Lordship. Your Lordship, identifying who else the data was shared with is far different from identifying the data that was used in the development of an application. An identity is, let's say, a person, a company. The data that was used in developing something does not fall under those two ambits. The second council equally noted that there are three requirements that have to be proved as per the Norwich Pharmaco Company versus Customs and Excise Commissioners for this order to be granted. Firstly, a good arguable case. Secondly, the defendant must be mixed up. And thirdly, the defendant must be in position to grant the information. Your Lordships, I shall under Section 101 and 102 of the Evidence Act of Uganda, the burden of proving specific things, such as these elements, falls squarely on the applicants. The applicants, second counsel in specific, has failed to discharge this burden. Your Lordships, even
so you're saying in this case your clients are mixed up is no wrong. There's no wrong they're mixed up.
Much obliged, Your Lordship.
Even when your colleague has just confessed to us that there is a sale which occurred.
Much
and
obliged.
he was even pleading with us to sever that sale. So there's a clear wrong from your colleague's submission.
Much obliged, Your Lordship. In these elements, the three elements are cumulative. Failure to prove just one element will make it impossible for the court to grant this order. There are three elements, Your Lordship, and in the first case,
we are engaging you on the specific one of being mixed up in the wrong. We don't want you to recite for us the elements. We're now being particular on one of those elements. Your co-counsel has told this court that there was a sale which was not proper under Section 37 and that we should sever it. Now, coming to your issue, doesn't that automatically equate to your client has already committed a wrong, or within the meaning of that case, your client is now mixed up with that wrong, which you want us to sever? So I want you to harmonize with his submission.
much obliged, Your Excellency,
Yes.
Your Lordship. I'm going to go to my co-counsel's submission, but I shall first proceed to the applicants. Your Lordship, as I've earlier stated, the applicants, in as much as my co-counsel had stated that probably there was a wrong,
Cavendish courtroom, the judges felt by a decision of 4-1 that Team TLME, who represented the respondents by a 4-1, won that particular moot. Congratulations to Team TLME. In semi-final round 2 between TLMK and TLMA, in a session that took place in Moot room number 1, their lordships felt in a split decision of 2-3, that Team TLMA won that round. So congratulations to Team TLMA. I will request the representatives of these two teams to kindly move forward to pick lots. The representatives, can we please move as fast as we can? Where is Team TLME? This is not very difficult to do. We need just a representative. Yes, so you will pick from the lots that will determine your position. Okay, so it's been decided for the final round, we shall have Team TLME as the applicants in that round. Kindly take your seats. And Team TLMA as the respondents. Please kindly take your seats as well. Alright, so these two teams are going to moot before a very distinguished panel, and I am unworthy to even dare to introduce the panel, but with great humility, allow me. The panel this afternoon is going to be comprised of Miss Alice Namuli Blazevic, who is going to be our lead judge. The rest of their lordships decided that in terms of seniority, Miss Alice Namuli would be better placed to be lead judge. She's a partner at Katende Sempewa Advocates. She established a record as have been a part of. You're most welcome, Your Lordship. The panel is also comprised of Mr. Augustine Idut, who is a partner with Kampala Associated Advocates, where he heads their tech practice. You're most welcome, Your Lordship. The team is also comprised of Mr. Paul Kalondo, and Mr. Paul Kalondo, sorry to introduce you at this juncture before I introduce the other lordships who are senior to you, but Mr. Paul Kalondo is an associate with BKA Advocates. He is a tutor at Uganda Christian University Mukono, and he has engaged in a number of moots, including the much coveted JSAP Moot. Before then, he also had successes at the Sehad Moot, and he has been one of the most feared judges during these rounds of mooting. Your Lordship, I do not know whether that round of applause is meant to bribe you or to enter your favor, but this does not in any way mean that your title of the most feared judge in the rounds is going to go away. We have Miss Diana Angwech. Miss Diana Angwech is the immediate past vice president of the Uganda Law Society. Ms. Diana Angwech has done a lot of work in terms of mentoring of young people. She was among the core team that established the rule of law clubs in this country, and she joins this very distinguished panel this afternoon. We also have Miss Irene Namuli, who works with ALP Advocates. She will also be joining this panel this afternoon. Can we give a round of applause to the distinguished bench that we have before us this afternoon? Now, I will quickly hand over to Your Lordship. I think the titles of Miss and Mr. have ceased from this point. Your Lordship, Alice Namuli, who will then guide the court on how we shall proceed moving forward.
Thanks a lot, Jordan. Good afternoon, everyone. It's not a very good afternoon for all of us here because we're supposed to have this session at 11 o'clock. So we had two options, either walk out on you guys but been very kind. Ivan, why are you laughing? Did you expect anything different from me? Thank you. So we've just been very kind, but it's also not a very good example actually we are setting, because you're also going to do the same thing to like the next generation. I would say it's an exception. It's something definitely, I guess next time you just have to be very cautious of the time. I hear we had a timekeeper, so I'm wondering, is that the person we should slaughter tonight, or? Because just imagine now, it's coming to 2 o'clock. The reason I emphasize that, so that next time we all do better, right? Yeah. So, unfortunately, some of us have to leave early. Like we said, this was supposed to be an early session, so we don't have much time. And we had been requested to give each team 30 minutes, but that won't happen because some of the judges have other engagements. And also, so we think that genuinely you don't need actually that. You have now final, you need less time, right? Right? The teams. Which is team A? Okay, these are the applicants and the respondents. So we've decided that each team should actually have 20 minutes. And then a rejoinder of 5 minutes each. We'll try as much as possible to not interject, because one, we believe that actually what you're going to now show us is the best that has come out of the past few days. That is, sorry, yesterday and this morning. So please be mindful of time. We just want each of you to have 20 minutes and then a rejoinder of 5-5. Is that okay? Okay, good. We'll start. Do you have anything else? Where is the timekeeper? Okay. You've not done very well since morning. I hope, pardon? Your apologies. Okay, good. So I hope you're going to do better. We have 20 minutes. When they're done, notify us, and then we'll go to the next team. So the applicants, please take the stage.
Much obliged, my lords. Appearing for the applicants, Council, Zara Nakilia. My lords, I'll be using 12 minutes of this honorable court's time to address you on jurisdiction, locus standing, and issues 1 and 2. My lords, my co-counsel, Tracy Niger, shall address you on issues 3 and 4. She will use 8 minutes, and we shall exercise our right to a rejoinder. My lords, the brief facts as known by the applicants are that Infinity Analytics, a data consultancy firm, entered into a partnership with the research wing of the International University of Applied Technologies, Uganda. This particular research wing is headed by Professor Owang, who conducts his research through questionnaires uploaded on the Brain Book. He collects such data wholesomely for 5 years, but the last 3 years, upon the installation of your life an entity registered in Ireland, he subjects that particular data to a cell. My lord, this professor collects data inclusive of personality traits. It includes political affiliations, locations, tastes and preferences, and in every 3 months, he collects 1 million user data. But then in 5 years, he sells that particular data to Infinity Analytics. It's on that background that my clients, Comrade Wagwez and 120 others, have instituted this particular case. My lord, this particular court possesses the jurisdiction to try this matter. We proceed to enforce the right to privacy under Article 27 of the Constitution of Uganda. Article 50 on the enforcement of rights, read together with Section 33 of the Data Privacy and Protection Act, provide that a person aggrieved by the actions of a controller can, before a court of competent jurisdiction, apply for redress. But unfortunately, my lords, this particular act does not define what a competent court is. But fortunately, my lords, Section 4, subsection 1D of the Human Rights Enforcement Act defines a competent court, wherein it provides that the High Court shall have the authority to try any suit in the enforcement of rights, provided it is far above the limitation of the pecuniary jurisdiction of the magistrates' court. On that foregoing, my lords, your applicants individually claim 10 million shillings and an aggregate of 1,210 million shillings for the infringement of their right to privacy. On local standing, my lords, your applicants fall within the classes of people from whom data was collected. Local standing was defined by your land colleague, my lords, Justice Mubiru, in the case of Dima Dominic versus Inyani, Uganda High Court case number 154 of 2017, to include such sufficient interest, actual, non-hypothetical, and non-academic. My lords, this professor collected data from various individuals, inclusive of students, inclusive of professors, inclusive of other employment categories to which your applicants fall. My lords, I will address you on the merits of this particular case. As enunciated earlier, I'll be submitting before your lordships on issues 1 and 2, particularly issue 1, which is whether the sale of data from your life to Infinity Analytics was lawful. My lords, I invite you to answer that particular question in the negative, while demonstrating why I'll be proceeding with 2 arguments. The first is that this particular sale was in violation, generally, of the data protection laws. The second argument is this particular sale was in violation of public policy and cannot be left to stand. My lords, under the first argument of violation of data protection principles and the laws, there are 2. I have 3 sub-arguments. First, that the sale was devoid of any consent at all. My lords, the other sub-argument is that this particular sale was, if it is to be considered in line of further processing, was way out of the legitimate interests under exceptions in section 17. My lords, the third sub-argument is to the effect that the sale, collection, control of this data that was sold to Infinity Analytics was in violation of the data protection principles, starting with the first, my lords, of consent. Section 2 of the Data Protection Act defines consent to be such freely given, informed, specific, and unambiguous indication or statement by a data subject that this particular subject is willing for the data to be collected, and that is absent, my lords. I will refer you to paragraph 5 of the facts, my lord, wherein the professor actually develops this particular entity, the brain book, to collect data, my lords. He uploads a questionnaire thereon. This particular brain book, my lord, is one of the very few entities from which people can access particular services like betting by way of USSD codes. My lords, it does not appear from the facts that any consent was given. The standard of consent given by this particular act is that it must be unambiguous. It must be a yes or a no, my lords. It cannot be imputed or inferred. Similarly, my lords, this particular consent, as was opined in the report by the Ugandan National Authority, by the UNATU, my lord, in the report as against the sharing of data by Safe Border, that particular commission, that particular authority, my lords, at paragraph 6, averred that mere access of an entity or an app does not actually amount to consent. To that end, my lords, I invite you to find that this particular cell was devoid of any consent at all. Proceeding to my other sub-argument, my lords, it is our contention that this particular cell was in violation of the data protection principles. It was the averment, my lords, of Lord Leggett in the case of Lloyd versus Google LLC, reported at page 50 of the UK Supreme Court cases of 2021, that data principles are the bulwark and foundation upon which the right to privacy is founded. An infringement on one leads to an infringement on various others, and therefore a collection, processing, or control that infringes on any one cannot be left to stand, my lords. It is our averment, my lords, that as seen from paragraph 6 and 7 of the facts, that this particular professor collected data which was aimed to be particularly for research and subjected it to a sale through your life, my lords. That is against the principle of fairness. The principle of fairness entails you to actually collect legitimately data and apply it for the specific reasons for which it is collected. It is the same spirit in which section 2 of the act is constructed, my lords. That equally means that where this particular principle has been violated, the principle of accountability too has been violated. I invite you to find that this particular sale was unlawful. Proceeding to my second limb of argument, my lords, that this particular sale was in violation of public policy. We aver that in as much as the sale was in violation of consumer protection principles and competition law principles, my lord, it cannot be left to stand. It is a fervent assertion of consumer protection that the market players, more so the producers in the digital and other sorts of sectors in the economy, must put the protection of the consumer at the utmost, my lord. Competition law entails that a company or an entity that seeks to top the markets of a country must do so fairly, but not sacrificing its consumers while getting to the top. My lords, I invite you to derive persuasion from the German Bundesklagemat Court, which is the High Court of Germany, in a matter between various claimants and Facebook, judgment of 19th, 2019. My lords, in that particular court, the judge held that in as much as Facebook, through installation of other platforms like WhatsApp and Instagram, connected to their particular Facebook entity, they violated consumer protection principles and competition law by requiring the disclosure of content connected between WhatsApp and Facebook without the consent of the particular people. Equally, that put them at an advantage, even though in violation of data principles, because then Facebook was outsmarting unfairly through violation of privacy other market players, and court found that that was unlawful. In as much as seen from paragraph 8 of the fact that this particular sale was aiming at boosting the sales of Infinity Analytics, it was in violation of competition law. My lords, as my time is fast spent, I'll yield the floor to my co-counsel to address you on issues 3 and 4.
Much obliged, Your Lordships. As earlier introduced, my name is Naiga Tracy, and I shall address this court on the third and fourth issue in 8 minutes. Your Lordships, under the third issue, which is whether the applicant is entitled to the no-wish pharmacal order that they seek from this court, it is the applicant's contention that this court should grant the no-wish pharmacal order because the defendants have information that is vital to the applicant's case. In support of our argument, Your Lords, I shall advance one issue, and that is the justiciability of the no-wish pharmacal order in Uganda's jurisprudence. Your Lordships, this no-wish pharmacal order was first seen in No-Wish Pharmacal Company versus Excise and Customs Commissioners at 1973 UK House of Lords at page 6, wherein the UK House of Lords indicated that for one to be granted this order, there has to be an innocent third party holding information that is vital to the applicant's case. Your Lordships, this order has, however, been modified by our statute, the Data Protection and Privacy Act, under Section 24(1, that mandates that a data subject has a right to access their data from the data controllers. Your Lordships, this order has also been adjudicated upon in DFCU Bank Limited versus MTN Uganda Limited and another miscellaneous application number 640 of 2019. In this matter, there was propagation of false news by the respondents, and Your Lordships, the Honorable Justice Musa Sekana in that particular case laid out a 3-part test that has to be fulfilled for one to be granted this order. That test entails a good arguable case. Defendant must be mixed up in the wrong, and the defendant must be in the position to grant this order. Your Lordships, I shall prove the 3 elements and justify why this honorable court should grant us this particular order. Moving on to the first element, existence of a good arguable case. My co-counsel has ably illustrated that the respondents have violated specific provisions of the Data Privacy and Protection Act. For instance, Section 3 of the Data Privacy and Protection Act mandates that one has to collect data fairly, legally, and with justice. This has not been done by the respondents. Your Lordships, I would like to guide this court to paragraph 7 of the facts and paragraph 4 of the facts, where Professor Owang puts up a questionnaire, goes ahead to put a clause that whoever logs into the brain book is going to submit the data to brain book. Your Lordships, in as much as the respondents might argue that logging in amounts to consent, the Safe Border Report, the NITA Safe Border Report of 2021 has highlighted that that does not amount to consent. Consent has to fulfill the premises provided for under Section 2 of the Data Protection and Privacy Act, whereby it has to be informed and ambiguous, Your Lordships. That does not happen from the facts that have been given. I shall proceed to the second element, which is the defendant must be mixed up in this breach. Your Lordships, from the facts, we see that under paragraph 7, Professor Owang starts up the application called Your Life. And this application is the one that is being used to collect the data. From the facts also under paragraph 12 of the facts, the applicants are suing 4 specific defendants. Your Lordships, these defendants are Infinity Analytics, Professor Owang, the university, and Brainbook. Those 4 defendants are mixed up in this wrong, in the fact that they are the professor is the one that has collected this data through Your Life, and also the fact that it is upon the directions of the directors of Infinity Analytics that he collects this particular data, that he starts up this particular app. Your Lordships, I shall move on to the 4th element, which is the defendant must be in a position to grant the information. Your Lordships, as I've earlier illustrated under paragraph 7 still, Your Life holds this data, but who is the mastermind behind the starting of this particular application? That is the professor and Infinity Analytics. That means those 2 particular bodies are are actually in the position to grant this data. The respondents might as well argue that this particular body is a different entity. It is a person of its own, a legal person. But in Stanbic Bank Uganda Limited versus Ducat Lubricants Uganda Limited and others, the High Court, Justice Madrama, stated that the corporate veil could be lifted in instances of fraud. Your Lordships, the professor, under paragraph 4, it stated that he's collecting data for academic purposes, but we later see under paragraphs 9, paragraphs 7, that he sells this data to Infinity Analytics with an agreement that existed prior. That shows that actually there was fraud. The intention of the professor is very much seen through those facts. I shall move on. And having proven those elements, Your Lordships, I pray that this court grants us the no-wish pharmaco order that we seek from it. I shall move on to the fourth and last issue, which is whether the applicants are entitled to the remedies sought from this honorable court. Your Lordships, it is our stand that we are entitled to the remedies that we seek from this honorable court. We proceed under section 33 of the Data Protection and Privacy Act to seek for compensation of 10 million per individual from this court. Your Lordships, we seek general damages from this particular court. The section mandates that there has to be damage or distress suffered by the applicant. And distress, Your Lordships, has been defined in Vidal Hall versus Google LLC to mean non-impactful damage that has been caused onto the applicants. Your Lordships, under paragraph 9 of the facts, we see that through the article of Mr. Bobrisky in the next, the data subjects get to know that actually the consent they gave for their data, it is not what they are using it for. They are actually selling it without their permission. Your Lordships, this data has moved from Your Life to Brainbook to the professor to Infinity Analytics, and now under paragraph 8 of the facts, there are big tech companies that are vying for this particular data. Your Lordships, the applicants are very distressed and they seek upon you, Your Lordships, to grant them compensation that they seek from this court. Your Lordships, as for damage, under the Kenyan case of Catherine Njero versus Machakos University, the applicant was able to get compensation because the respondents had used her picture for commercial purposes. And again, under paragraph 7 of the facts, we see that the data of these particular subjects is being used for commercial purposes. Your Lordships, we pray that you grant us those particular damages that we seek from this court. Moving on, we also seek a permanent injunction from this honorable court, and we proceed under section 33 of the Judicature Act that mandates that this court shall give remedies that they deem fit in a particular matter before it. We also proceed under section 38 of the Judicature Act to request for an injunction from this particular court. The purpose of that injunction, Your Lordship, is to stop and prevent Your Life, Infinity Analytics, the professor, the university, and Brainbook from going ahead to use this data for their fraudulent reasons. Your Lordships, we request you that you look through this matter and give the applicants the remedies that they seek for from this court. If I'm of no further indulgence from this court, Your Lordships, I pray that this honorable court grants the no-wish pharmaco order, as well as the remedies prayed for by the applicant, and any other remedy that we might not have prayed for, but it is deemed by this court to be justified. We also pray that the costs of this particular application are granted against the respondents. We rest the case.
That's it, right, from your side? The other colleague, no. We'll have questions from the bench. Would you like?
Hello, all right. Just to Council Dalton, please take the podium. I just want to clarify a few things that you alleged. Council, one of the things that you asserted was consent And I want to clarify, as you were alleging that there has to be consent, was the consent that you said Professor Owang needed to have, was it consent for the data that he was collecting, or was it consent to give away the information?
Much obliged, my lord. The consent that I was hinting at, my lord, is the consent to give away the data, my lord. And also the consent that I was hinting at was the consent from Infinity, the consent for Infinity Analytics to collect the same data from your life, because section 11 of the Act says that data shall be collected from a particular individual, and the exceptions are laid out in subsection 2 of that particular section, but the respondents do not ably fall in any of those exceptions, my lord.
So, in Professor Owang's collecting the data, are you saying originally when he carried out the survey that he had no consent to obtain that data?
Much obliged, my lord. The consent he had specifically was for research as laid out in paragraph 5 of the facts, but it cannot be reasonably expected, even if, my lord, we were to apply the further processing as seen in section 17 of the Act, that a data subject could expect the consent given to extend to a sale, my lord. The consent was specifically for research, but then there comes in a sale, which is very much far apart from the original consent obtained.
Okay, that's just clarification. Should I move on to Tracy, or does somebody, another judge, wish to ask? From the podium.
My lord. Yes, my lord.
Seems to provide for an administrative procedure through which such complex can be handled. I'm just wondering why in times you don't pursue that remedy and instead chose to come to this court. Yet, the Uganda would have already remedy this kind of thing, as in the stakeholder report that we cited. Why this court?
Much obliged, my lord, and in response to your question, first, NITAU is an administrative body which offers administrative remedies. However, section 33 of the Act, my lord, says a person who suffers distress or damage shall appeal to a court of competent jurisdiction. In the safe border report, the data subject therein did not prove or even allege any distress, my lord. And also, I invite you, your lordship, to find a persuasion from the decision of the UK Court of Appeal in Vidal Hall versus Google LLC, wherein that particular court interpreted section 13 of the Data Protection Act of England, which is actually in pari material with our section 33, to actually point to the fact that one has to prove damage, not only mere damage, not damage and distress, and not only mere distress, but material distress. The court also rightfully held, my lord, that mere breach of a statute of the Data Protection Act of England does not warrant a remedy in court, but the proof of distress and damage. And that, my lord, I believe my co-counsel ably proved when she pointed to the fact that this particular sale was founded on the exchange of this data from the brain book, the professor, the YouLife, up to Infinity Analytics. We don't think, my lord, that you can put something on nothing and expect it to stand. It shall fall. So we aver, my lord, that that particular section justifies our suit before your lordships.
I would like to confirm with you, do you accept that the data that was obtained by Dr. Ogwang in the first instance, that's from the students, or for the data which he collected under the disguise of research was obtained legally.
Much obliged, my lord. In my opinion, actually, as the applicants, we assert that even that particular consent fell below the standard of consent enunciated in section 2 of the Act, because that standard, my lord, is that the data must be freely given, it must be specific, unambiguous, and informed. Unfortunately, freely given consent is not defined in our laws, but the European Union guidelines on consent, particularly Regulation 3.3, defines free consent to entail the acceptance or denial of the collection of data arising from facts and circumstances and information provided by the collector, controller, or processor to the data subject. This particular individual, my lord, if this professor, it's in a paragraph 5 and 6, obtained data with the impression that it was for research and then subjected it to a sale, then that particular consent...
No, I understand. Those are there are two issues here.
Yes,
one,
my lord.
The first issue is the data that was collected by Dr. Ogwang for research, right? You want to cite the border case and all that, but I mean, we have the flexibility of dissenting from the previous judgments that have been passed, because I would want to know if I'm the data subject, right? By the time I go on a platform and fill in my data, right? I believe that you're as a data subject, I have some kind of duty, first of all, to read and understand what I'm going to do or what I'm required to do. Otherwise, unless you're saying that your clients lacked some, what they call this when you're applying, are they insane, or do they pass that test of insanity where before they actually provided their data, did they know, what were they doing? You understand? You can't plead ignorance for something where you actually also participated, right? So there's that aspect. So which means that they must have read the questionnaire, understood what they were required to do, and provided that data. And that data was for research. What I want to, before we go into data being repurposed, I want to find out from you whether there was consent. Do you understand? Like, if I'm the data subject, I go online, was it online or even on paper? I'm like, okay, I've received a questionnaire and I need to fill in this information. As Alice Namuli, I would not fill in that information unless I am satisfied that the information I am about to give is for the right purpose, I'm comfortable with it. Do you understand? Yes, there is that. So I never want you to remove the obligation from the data subject, because even under the Act, the data subject has obligations. So do you accept that Professor Ogwang obtained this data from the students or whoever he got from the data subjects? Was he able to obtain consent to some degree?
And if I may just add to what her lordship had stated, in your discussion, I really didn't hear any distinction or separation between a data collector, controller, and processor. And while you have multiple respondents or defendants on board, each and every one of them may or may not have played a certain role, and therefore may or may not fall under one of the three legs of data collector, processor, and collector. It would be helpful in responding to her lordship for you to also give some clarity to the legality of the data collection exercise. And in so doing, I would appreciate if you could also, looking at paragraph 5, the signing up or logging in criteria or process. You've made a presumption that there may have been no consent in the signing up process. That is something that leaves the court in a little bit of a spot of bother, because some signing up processes have an element of consent embedded therein, and that would therefore legalize the data collection exercise, as Her Lordship has stated. And if you move away from that to the next element of data, who therefore becomes the controller. Because if I legitimately collected data of any culpability in this case, and would I therefore be the collector, or would I also become the controller? And at what stage do I become culpable? I didn't hear any discussion around that, and I would appreciate if you could, in responding to Her Lordship, Her Ladyship, you also address those elements, which I would really need to understand the structure and substance of your arguments. Thank you.
Much obliged, my lord. Starting with your question, my lord, I would bring it. I would refer my lordship to paragraph 4 of the facts that actually points out that the university under which the professor works is a registered collector and processor, my lord. But then our assertion is that this particular professor acts in his capacity as a controller, where he is not registered as such, my lord. Even if we to infer the principle of agents, his principle is not registered as such. Controlling, my lord, is defined by the act as a controller is defined by the act, my lord, as a person who singly or severally with others determines how and in what manner data is processed. This particular professor collected data, and in his own workings, through the development of ULife himself, he determined that this data, which was for research, should instead be for a sale. He was not processing there. He was determining how it was going to be processed and for what reasons. He acted as a controller. He is not registered as such. My lord, then proceeding to your ladyship's question, on consent, my lord, in this particular era of digitalization, there is a requirement on data entities to actually be very compliant and be very much aware of the essence of consumer vulnerability, my lord. It follows, as I enunciated earlier in the German case, that even where your app, as Facebook was in that case, even where your app offers such particular elements, it does not amount to consent, because consent is specific usually. It's for the reason for which it is collected. Where you need to process, again, you seek more consent. This
You're confusing two things.
Yeah.
You're saying he sought consent, but then he transferred it. Those are two different things. And I want us to be clear, because before I can obtain data on behalf of my law firm, right? And I would be acting on behalf. Dr. Ogwang is a professor at this university, right? So why are you saying that he was acting in his personal? Two, there are two. I want you to distinguish the two. I can obtain data, and that's okay. I can obtain it from him, from everyone here, with consent. But the way I repurpose that data could be is a completely different issue. And before I repurpose the data, I must seek consent again from the data subjects. So, but we will need to agree. Do you agree that the first instance when Dr. Ogwang collected this information on behalf of the university, was it valid? Did he do it legally? Why am I insisting on this? Because your colleague actually said that your clients were very surprised that the data they had consented to be collected had been, is being repurposed or being sold. Do you understand? So you actually don't have to take to, you could concentrate on the strength of your case. Where is the repurposing? And also I would want to ask you, in this particular case because it's also not very clear, was it on a digital platform? Was it hard paper? Because there's there are consent tools on a digital platform, and there's also consent on paper. There should be some kind of signature. The signature online is also could be different, because I know in some cases that when you press the OK button, after you filled in all this data and read all the terms and conditions, that's basically, it's considered as what? Consent. But then on paper, it could be difficult that, did these people sign?
No, my lord.
They didn't sign. They didn't sign at all.
They didn't, my lord.
So why was your colleague then she said that she was surprised that the data they had consented to is now being sold to a third party? In herself, she mentioned that.
Much obliged, your lordship. Preliminarily, to answer your question on the entity, it is at paragraph 4 of the facts, line 4, the last line on the first page of the facts, that indicates that Professor Owang developed a platform known as Brainbook for the purpose of research. My lord, at paragraph 6 of the facts, it is indicated that through this particular Brainbook, he uploads his questionnaires, and that people like the youths through it access services like baiting through the use of USSD codes. Our assertion that there was no consent, my lord, is because it is not indicated anywhere from the facts that this particular entity had the various mechanisms to inform this particular data subjects of their requirements and to what they are consenting to.
So why did your clients give this information?
Much obliged, my lord. My assertion on that and response to your lordship is that Brainbook, being one of the few entities that actually offer such services, as I mentioned, like baiting, is acting as a monopolist. Therefore, a consumer has limited choice, really, my lord. You want to access something, but it's only accessible through giving out particular data.
Okay, we need help with the microphones. Are you then suggesting that they were forced to take the survey? Is that your assertion, counsel? If you're saying they did not consent to giving away their information, were they forced to take the survey?
My lord, they were induced indeed.
How were they induced? From the facts. Before you, how were they induced?
Yes, my lord. From the facts, it is indicated that this particular entity is one of those. It's actually the only entity from which these particular individuals, the data subjects, can access particular services, my lord. So you find a data subject in need of really using a service, but they have to give information their own. So they choose to give the information and use the service. So that particular consent is really induced in one way or the other.
Councillor Dalton.
Yes, my lord.
I seem to be losing track of your argument. In the first instance, you seem to be separating Professor Owang from the institution he heads. Is it your argument that these are two distinct entities and the actions by Professor Owang are not binding on the registered university as the data collector and processor? Is that your argument to begin with? Because then it seems, from where I'm sitting and listening, you seem to be saying that it's only the university that's registered, and Brain Book, which was created by a professor, is an illegal outfit on a frolic of its own, and whatever it's doing, it's therefore illegal. Is that, am I right in what I'm hearing, or at least the conclusions I'm reaching?
Much obliged, my lord. Our contention in response to your question, my lord, is that the professor, as required by Regulation 15 of the Data Privacy and Protection Regulations as of 2021, is required to register as an independent controller to the extent that he controls data, my lord. Where he does not where he proceeds to control without registration, he will be personally liable because this particular act has the element.
We're talking about the collection. The question started from the legality of the collection, and I think that's where most of the questions are really, from what the chairperson, was the collection lawful before you go to the control and the processing? And again, going by what your colleague, Council Tracy, had stated, where she had conceded, or at least in her statement, that there was consent. So we want to understand, before you go to processing and controlling, was the collection lawful?
My lord, the collection from the Brain Book was unlawful because this is a cyberspace entity. My lord, my appreciation of cyber law, as from the land author Kyang Sak in his book Public International Law on Cyberspace, he was that these are actually individual entities existing in cyberspace because internationally there is no particular national cyberspace law. So where an entity operates online, my lord, it is not connected to its maker, but rather the particular country. And that particular land author, at page 25 of his book, he posits that nations should then exercise passive personality jurisdiction in order to bring those entities where their actions affect the individuals of your particular country. Then you have to bring them to accountability in your country, bringing them from the jurisdiction from where they are in cyberspace to the ambit of your particular law. And interestingly, my lord, at paragraph 4 of the facts, actually 5, this entity, they are aware that they are indeed an online entity, not registered in Uganda and not under the regulation of Ugandan laws.
Okay.
We are taking a lot of time.
I think to answer the Lady Justice's question, you need to understand the relationship between Dr. Owang and the university, which you have not given us. What is their relationship? And when he was acting and picking this information through Brain Book, was he acting on behalf of the university, on behalf of himself? In what capacity was he collecting this data? And once you answer that question, then you get to know whether the data was collected legally or illegally. Okay?
Yes,
please
lord.
give that guidance and then we'll answer the question and move.
My lord, the professor acts as an agent of the university. But then, interestingly, in section 38 of the act, this act is in spirit of even punishing workers of entities who flaunt data privacy laws. In that particular section, the professor too equally could be punished by law, and I invite your lordships to actually
Before we get to the punishment,
Before you get to the
punishment question, was the data collected legally or illegally? You've just told us he acted as an agent of the university. Which university is registered to collect data and process personal data, right?
Yes, my lord.
So if he's an agent, did he collect the data legally or illegally? Is the question we're asking.
Much obliged, my lord. He collected. He collected this data acting as a professor of the university.
Thank you very much.
That's enough. Can we, I just have a few questions for your colleague. What's your name again? Tracy. You talked about damages. You're seeking damages, right?
Yes, Your Lordship.
How much is it?
10 million per individual.
And how many are they?
121.
121. Can you've not shown us in any evidence that your clients were actually distressed or actually suffered this damage. You know, you're supposed to actually prove to us before. It's not about seeking damages. You know, the fine, the penalty, the major penalty for data breach is a fine, which would usually impose on in your case it would be Dr. Ogwang, right? And all the other parties from the respondents. And that fine actually would be going directly to, it wouldn't even be direct, it wouldn't be paid to your clients. The Act requires you to go over and above what pretty much the damages you're claiming in simple terms and prove that your clients suffered those damages. You've not given us any example of what happened, what were the consequences of that data after having been repurposed. What did they suffer? Did their records I don't know, were they deleted? Did they go missing? Did someone, just because of that data breach, did they suffer any security? Did they suffer any losses in their businesses? You've not shown us that evidence that they actually suffered loss, because you should prove that, well, this data subject used to operate and run this kind of business, but then because of this data breach, my clients or 10 of your clients' businesses suffered this amount of loss, right? That is the kind of evidence we want. You just cannot come up with 10 million shillings. Show us how the 120 people, each of them suffered the damages you're asking for.
Much obliged, Your Lordship. The applicants suffered damage. That is our stand. Paragraph 9 of the facts. I'm going to start from paragraph 9, then move to paragraph 8. Paragraph 9 of the facts, that's where we see the article by a former employee of Brainbook saying that actually the data that was collected was not being used for what it was collected. And we see that actually that data is being bid upon by major tech companies, and also it has attracted keen attention of the Uganda Bankers Association. Your Lordship, I cited the case of Catherine Njeri versus Machakos University, whereby the commercialization of her data was taken to be damage to her. And here in the facts, we are seeing under paragraph 9 of the facts that actually the data was being used for commercial purposes. I beg that this court is persuaded by that decision because of the principle it has enunciated.
No, I disagree entirely. I want you to show me, because I could, if I'm using, for example, Facebook, and I go into Facebook and I find out actually Facebook has repurposed my data to Irene's company, right? I need to show that because Facebook, while I went on their app, and most probably it was my pictures, it would be for my children, and then her company used that data for advertising for children's, I don't know, like parties and everything. I need to prove that because of that breach, right?
Yes.
My children, maybe God forbid, something happened to my children, or I suffered some kind of loss, or I collapsed, you understand, in hospital, and I had to pay, these kind of damages. Yes, all these cases could be there, but remember, that's not the alpha and the omega, right? So we are definitely at liberty to dissent. Okay.
Yes, Your Lordship.
I just want you to give me an example of one, just one. You have 120, just give me one example of the evidence that your client suffered damages.
Much obliged, Your Lordship. To answer your question, I would like to first refer this court to the lead case on this particular section, which is Lloyd versus Google LLC 2021, where the UK Supreme Court highlighted that there has to be proof of material damage or emotional distress. However, that case is much contrasted with our Act. Section 33 requires just existence of damage or distress. Your Lordship, a faithful reading of that section, along with the facts in question, does not mandate that one has to come and present forth that this is the damage that I want. However, when we look at our facts in question, Your Lordship, I'm going to start with Comrade Wagwez. The applicants come before this court not because they are happy about the sale of their data, but because they are aggrieved by that sale. Your Lordship, that in itself shows that they are damaged, they are distressed by the sale.
They could actually suffer, they could be penalized for that breach, right? But for you to come up with damages, because just think about it in just fair terms, what made you come up with 10 million per person? Why not 5? Why not 500,000? Why not 2 million? Why not 100 million per person? Do you see the fairness of it? That's the reason why you must equate the damages to what actually the loss that someone has suffered. Otherwise, I'm scared that you've just come up with this fee from, rather the sum from, oblivion. Like, what exactly? You should show us that because they actually incurred maybe this loss in their business amounting to 5 million shillings, we would therefore ask for 7 million shillings. Or because they suffered some kind of hospital bills, they paid 10 million, now we're asking for something of that sort. You have no evidence at all. So how fair is it that you've actually come up with 10 million shillings?
Much obliged, Your Lordship. The damages we are seeking are general damages, and these are specifically granted by the court at their discretion. Unlike the damages that Your Lordship is referring to, specific damages that ought to be proved and pleaded by the applicant, that is not what we are seeking. Secondly, Your Lordship, we see from the facts under paragraph 12, line 4 of the facts, that the data privacy of millions of users has been violated.
Okay, just want to take you to a different angle. And that's in respect of, I think, issue 3. You started your argument by citing the considerations for the issuance of an NPO order. And you subsequently started that being at least being an equitable relief. You started talking of fraud as a basis for the issuance of the order. As a member of this panel, I'm not persuaded by the citation of fraud in an application for an NPO order. And I just wanted you to clarify as to whether fraud as a ground for the issuance of such an order is really feasible in the current circumstances. But most importantly, before my land sister chips in, you have about 4 defendants, right, in the main suit. Can this court exercise its discretion to issue an NPO order against
people have been by the activities of the respondents. That is why we come before this court so that it invokes its power against the respondents and set precedent for what should be followed in data collection, controlling, and processing.
Okay, thank you very much. That's it, thank you. Oh, you're still submitting?
I hadn't answered her ladyship's question. As for the need for this order, your lordships, under paragraph 13 of the facts, we are seeking information about the development of your life. Your lordships, the data that is being collected through your life, and that is the means through which the professor is getting this data. We also need to know which kind of people under section 24.1c have had our data, as well as under section 24.1a have had access to our data, and what have they used our data for, because we need this information to boost our case as per the spirit of the court during the initial of this order.
Isn't that a fishing expedition?
Your lordship, it is not a fishing expedition. We have proven before this court that there were violations of the Act. We have proven before this court that the respondent is connected to the violations of this Act. We have also proven before this court that the respondent is in place to give us the information that we seek. Your lordship, that is the criteria under FDC versus MTN that is mandated to be fulfilled for this order to be granted. A fishing expedition, on the other hand, would mean that we have none of those criteria. However, we come before this court because we feel aggrieved. But we have specifically proven before this court that we have what it takes for this order to be granted.
Thank you very much.
Much obliged, your lordships.
And we have the respondent.
May it please this honorable court, I am Asimwe Davis Majisha, appearing for and on behalf of the respondents in this case with my co-counsel, Ms. Wendy Kasemire, and our lead researcher, Ms. Samantha Mwesije. My lordships, with your indulgence, I beg to shed more light on the facts of this case, precisely because the applicant in this case has deliberately made omissions concerning matters that are pertinent to our submissions. One, that under paragraph 4, lines 1 to 2, the purpose for the partnership between Infinity Analytics and the International University of Applied Technology, Uganda, are particularly stated for the research for the development of your Muller application. And under paragraph 5, lines 1 to 2, the purpose of this survey is stated: Professor Ogwang research for personality preferences for the development of the Yo Muller application. My lordship, your lordships, the respondent does not contest the requisite jurisdiction of this court to hear this matter. However, we contest the admissibility of this case before you, my lords, simply because the applicants in this case did not adhere to the procedure provided for under sections 31 to 34 of the Data Protection and Privacy Act, particularly the right to apply for remedy to the authority under section 31, and the mandate of the authority to investigate and award remedies to the complainant under section 32, and in the event that the applicant had applied and not been satisfied by the authority's decision, an appeal to the minister is provided for under section 34 subsection 1 of the Data Protection and Privacy Act. It is for this first reason my lords, that the respondent argues that the applicant's case is not admissible before this court. Secondly, paragraph 12, line 1 of the facts clearly state that this is a class action suit. While we do not have class action suits in Uganda, my lords, we have representative suits. Representative suits were referred to in the case of Honorable Justice Professor Dr. George Kanyehamba and 320 others versus Amos Nzei and 3 others. And this is a High Court decision delivered by Justice David Wangutusi, particularly laying down the prerequisites for representative action. One being that the individual purporting to represent others must inform them in order to be made part of the suit. And secondly, that the individual under Order 1, Rule 8 of the Civil Procedure Regulations has to add a list of all the parties that they intend to represent in this suit. My lords, it is important to note that none of this has been done by the applicants and no leave of court has been sought. Proceeding to issue 1, in the event that my lords are not particularly persuaded by the respondent's argument on the preliminary issue of admissibility, and in response to the argument of the applicant on issue 1, that the sale of data from Your Life to Infinity Analytics was unlawful because it lacked consent. My lords, it is the respondent's submission that indeed consent was given, particularly to BrainBook prior to the collection of data, under the guidance of Section 7.1 of the Data Protection and Privacy Act, and in defense of Your Life, which is the one that sold this data. Your Life is a firm established under the laws of the Republic of Ireland, and this is data that was collected from over 1 million users across Uganda. Section 11, subsection 2, paragraph G of the Data Protection and Privacy Act provides an exception to Your Life. In this particular instance, Your Life is permitted under this provision that I have stated to get data from BrainBook in the event that they cannot reasonably and practically get consent from each of the more than 1 million users across Uganda whose data has been collected. My lords, it is alternatively argued by the respondent in this case that even the data that was sold by Your Life to Infinity Analytics does not pass the qualification that is provided for under Section 37, subsection 1 of the Data Privacy and Protection Act, particularly being personal data. My lord, Section 2 defines data as information that is collected and is due to be processed or to be part of a record, while personal data is used particularly, can be used particularly to identify the data subject from whom this data has been collected. My lords, I refer us to the jurisprudence of the European Court of Justice in the case of Patrick Breyer versus Bundesrepublik Deutschland, where data was distinguished from personal data. In this case, dynamic internet protocol addresses were collected and they were differentiated from static internet protocol addresses. Static internet protocol addresses being just data because of, how mobile human beings are. It does not suffice to be personal data. However, dynamic IP addresses would suffice for personal data in this case. It is important to note that the data that was collected by Professor Ogwang in of and in itself does not in any way pinpoint a particular user that provided this data. My lordships, Your Lordships, proceeding to issue 2, the applicants in this case submitted that your license of Guang, Infinity Analytics, and BrainBook are not compliant with the existing regulatory regime because they did not adhere to the principles of data collection provided, particularly fairness and accountability. On the principle of fairness, the first counsel for the applicant submitted that fairness required that the purpose of this data is particularly stated to the data subjects in this case. And this is the reason as to why I referred us to paragraph 5, lines 1 to 2, because it is very clear that Professor Ogwang conducted this research to identify preferences of users. It means that this data in its collection, initially, it was intended to improve and to aid in the development of the Yomula application. It now becomes absurd for the applicant to come and say that indeed they are not aware of this. The respondent therefore submits that we acted with fairness in the collection of this data. Secondly, the applicant submitted that the second principle violated was the principle of accountability. And they submitted that accountability was non-existent because the data subjects are made accountable to the data subjects because there's no form of effecting the grievances of the data subjects in this case. And I refer us to paragraph 10, lines 4 to 5 of the facts, my lord. And the facts are very clear. The CEO of BrainBook made it very clear that if required, an app to delete all BrainBook web search data would be developed. This goes to show how intentional and how accountable BrainBook is to the data subjects because they are willing to adhere to the requests and demands of the data subjects in this case. My lords, this has been the submission of the applicant on merits 1 and 2. I relinquish the floor to my counsel, Ms. Wendy Kasere, to submit on issues 3 and 4 and to make the prayers for the respondent. Thank you very much.
Much obliged, my lords. It is an honor to present before such an honorable bench. My name is Wendy Kasemere for the record, and I'll be appearing with Mr. Davis Mujisha on behalf of the respondents. I'll be addressing the third and fourth issues. The third issue, that the applicants are not entitled to the Norwich Pharmaco order. Basing on the previous submission of the applicant's second counsel, the second counsel mentioned prerequisites that are needed to obtain a Norwich Pharmaco order. I would like to make clarity that a Norwich Pharmaco order is sought for evidential purposes because it was defined in the case of Norwich versus Excess Commissioner that a Norwich Pharmaco order is an order sought against defendants by the claimants to obtain information in order to find the wrongdoer or to find liable a person that has made violations. Basing on the previous submissions of our first counsel, we see that no violations have been made in regards to the respondents' actions. The applicants argued that there was violation of consent and there was sale of visa data that violated the sections of the Data Protection Act, respectively, the Section 7 of the Data Protection and Privacy Act and Section 37 of the Data Protection and Privacy Act. I would like to address this court and mention that no, the principle of consent was not violated, in the way that all the information that was obtained by Professor Wang from the data subject was given of free will to the data collector, which means that no violation regarding consent has been made. And secondly, I'd like to mention to the Honorable Court that the first applicant mentioned that when one principle of data collection is violated, all the other principles have been violated. I'd like to make there is no statutory provision anywhere that when one principle is violated, all the principles concerning data protection have been violated. It is not legal. I move to the second prerequisite, that the second counsel on the side of the applicants mentioned that the party has to be involved in wrongdoing. My lords, I'd like to bring to your attention that we have proved that there has been no sale of personal data regarding Section 37. Section 37 of the Data Protection and Privacy Act expressly provides that it is an offense to sell or offer to sell personal data. But basing on our facts, we see that there was no sale of personal data, but there was simply sale of user data, which is not an offense under the jurisdiction of this court and the Data Protection and Privacy Act. We also see that consent was not violated. So if someone has not committed any violations, are the applicant surely entitled to this Norwich Pharmaco order? I'd also like to bring to your attention that the case used, and this they did not, I'll address the case either way. It's Mitsui versus, so in 1974, in this case, this is where the prerequisites for obtaining a Norwich Pharmaco order were laid out. But we see in the case of EUI Limited versus Vodafone UK in 2021, these prerequisites were dismissed, and the judge said that the judge mentioned and established that these prerequisites are no longer fit to be used as criteria for Norwich Pharmaco order to be granted. So I pray that the Honorable Court considers this. Moving on to the point made by the applicant, address the position of the injunction sought by the applicants. And my third issue, the applicant sought for an order at a permanent injunction. I'd like to mention that there is no provision for a permanent injunction in any statute deemed by law in Uganda. And I will further explain the prerequisites that have been set out by by precedent in the cases of Chagulanyi Sentamu versus Commissioner of URA, and also Seranga and others versus Diamond Trust Bank. In these cases, it was repeatedly expressly explained that there shall be two prerequisites for which an injunction shall be granted. There has to be a prima facie case with high probability of success. And I'd like to address this Honorable Court and mention that if no violations have been made for the respondent, then why is an injunction being sought by the applicant? Because you seek an injunction to stop a particular body or person from doing an act that can subject the infringed party to suffer irreparable damage. Damage cannot be suffered if an infringement has not occurred. We have clearly stated the infringements that have been brought up by the applicants, i.e., for example, the sale of personal data and attaining of data without consent, those violations have not occurred. They have not been done by the respondents. So basing on those two prerequisites that have been given by the Statute of Uganda to provide an injunction, to be specific from the Civil Procedure Rules Act, basing on those two prerequisites, the applicants are not entitled to be granted the injunction that they seek. Moving on to the fourth merit, the applicants seek damages. Specifically, they seek damages of 10 million to each person who they believe their privacy has been infringed. My lords, I'd like to bring to your attention that the right of privacy has been embedded in Article 27 of the Constitution of Uganda as amended. It has also been expressly provided for under Section 10 of the Data Protection and Privacy Act. Would like to as the respondents, we submit that the right to privacy has not been violated because the data subjects gave their data to the data collectors out of free will, and at no one point were their passwords or data stolen. All the data that they gave to the data collector was given out of their free will. We also bring to your attention that there was no unlawful sale of personal data as established by Section 37 of the Data Protection and Privacy Act. It has been established as an offense if sale of personal data or offer to sell of personal data. But we see that the respondents have not made these violations. So we clearly see that the right to privacy has in fact not been violated. So my lords, I pray that you find it fit that the applicants are not to be awarded any damages, because on top of not proving that there have been any violations, they have also not proven the impact that these apparent violations that they believe have occurred. In the case of Hall Brothers versus Young, the judge expressly determined that damages shall be awarded to infringed parties to revert them in a position they were before the infringement occurred. The applicants have prayed to this court to be awarded damages of 10 million, but they have not shown us the impact of the apparent infringement. They have also not shown us if they were in a position where they had this 10 million and this apparent violation put them in a position where they lost this money. I'd like to conclude on the submission of the respondents by praying that this court finds the transaction between Infinity Analytics and Your Life to be lawful, that our clients are found to be in compliance with the existing regulatory regime, and also that this suit is dismissed because no violation of human rights in specification to rights of privacy have been infringed, and lastly that this suit be dismissed and the applicants are made to pay costs to the respondents. We so submit as the respondents. Thank you, my lords.
Okay, we'll start with Councillor Davis. You can take your seat. Thank you for your presentations. Councillor Davis, just quick clarifications. Is it your submission that no personal information and no personal data was collected by Professor Wang?
Much obliged. Personal information was collected, but no personal information was sold.
So you were saying personal information or personal data was collected, but none of it was sold. And you were certain. So what was sold if not that wasn't sold? If it wasn't the personal information, what was sold?
What was sold was information that had been analyzed according to personality, traits, tastes and habits, political affiliations, and financial spending habits, as per paragraph 7, lines 4 to 6.
So you're saying the data collected through, do you want to read those lines for us?
Yes, my lord. The data collected through BrainBook was analyzed according to their personality, location, tastes and habits, their political affiliations, and financial spending habits. The information gathered through Your Life app from the users of BrainBook was sold to Infinity Analytics as per the terms agreed earlier.
So your distinction is that information that was collected is different from the personal information. So you're saying no data was sold. Is that your assertion?
Yes, my lord.
Okay. You also said that the applicants knew exactly what data they submitted and what the data would be used for. Is that correct?
Yes, my lord.
So you say the applicants knew exactly that everything that they were submitting, they knew what it was going to be used for.
Yes, my lord.
Where do you get that from?
Paragraph 5, lines 1 to 3 of the facts. May
please read.
Professor Ogwang, for his research project on consumer preferences, designed a questionnaire and conducted a survey using the BrainBook platform to understand personality traits and collected information from various stakeholders. From these facts, it's evident that 1. Professor Ogwang is collecting data on consumer preferences, and a questionnaire has been designed, tailored to this effect. It is the submission of the respondent in this case that a questionnaire is elaborate and it's express.
So you are asserting that if I do fill in a questionnaire today, I know what my data is going to be used for. Is that what you're saying?
Yes, my lord.
Okay.
I just want you to differentiate for me the difference between if I gave you information in regard to my location, what would you call that? If you have rather information in regard to my location, meaning my workplace, my home, would that be your information or it would be my personal information? If you got information of my address, if my address was leaked to someone else and that person came to my home, would they be attacking you or me? And would that information have personal an impact on me or the community? Because I just really don't understand what you mean by personal information when you have my location, my address.
Much obliged, my lord. So, I do not know where you live.
No, I'm saying the information has
yes.
people's location,
Yes.
personality. How do you get my personality? You just can't get it from wherever. I should give you some leads. I should give you information about me. It could be my age. How do you get to know someone's personality?
Personality is how you relate with people. For example, I can't be described as someone with an extrovert personality, meaning that I interact easily with people around me. Be that as it may, I am not the only extrovert. And so if there is data that is published about an extrovert who is in Kololo, who lives in Kololo, who likes milk, and who is very, very saddened by Liz Truss leaving office and does not usually go to Acacia to spend, the odds of you identifying that this is Asiimwe Davis Mujisha in question,
I agree,
is close to zero.
My question is, how do you prove that when my personal info, to get my personality traits, how do you prove that it didn't have certain information, specific information to do with my age, to do with my name, my location, how many children I have, what evidence can you show us that actually whatever personality tests that were taken didn't include specific personal information for all the people they collected data from?
Can I? No, my lord. May I explain why? Okay.
I think let me try and assist you. Okay. Because the answer to your question is actually in paragraph 6. Read it carefully and answer, the Lady Justice. Professor Ogwang developed the questionnaire having the questions based on a psychometric model and collected the personality profiles of the participants of the survey and profiled every user with their personality traits. This was a questionnaire specifically developed. It wasn't for the research purposes. He specifically developed a questionnaire for this project. In paragraph 5, for his research project on consumer preferences, he designed a questionnaire and conducted a survey using the BrainBrook platform to understand personality traits and collected information from various stakeholders. Now use that information and answer the questions.
Much obliged. It is the submission of the respondent that personality profiles do not suffice, because in their nature they identify someone's external interaction with matter, with especially relationships with people. Personality concerns relationships, and so personality does not suffice to identify a particular data subject in the event that this personality is revealed to another. And so it is the submission of the respondent, my lords, that these personality profiles could be collected and could be put in place, but without particular sets of data that are provided for in the description of personal data under section 2, one would not be able to identify the particular data subject in question.
Councillor Davis, I'm still on the same issue my fellow panelists are raising. And I just want to indulge, I want you to indulge me, okay? We, through your concession now, know that personal data was collected, correct?
Yes, my lord.
So personal data was collected.
Yes, my lord.
So let me jump to the end. If the personality character that has been assigned to you is a gentleman who loves Adidas shoes and he loves going to restaurants of this caliber, he loves drinking Coca-Cola, and he loves iPhones, correct? Of what use with that will that data be to a Samsung manufacturer? If iPhone wants to target you and Adidas wants to target you, won't they be going to Infinity Analytics to buy data that would serve their commercial purposes so that they can know in utilizing and targeting a targeted consumer on Facebook, on Instagram for advertising purposes? We want to directly reach Davis so that our restaurant advert of, say, Cafe Javas does not go to your panelists, Samantha, right? Won't they be looking for data that can identify Davis through data processing and really manipulation? Won't they be doing that? Won't they want to be able to reach Davis at the end of the day for the ultimate beneficial users of this data? Isn't that the purpose?
And Davis, just as you answer my colleague's question, in the same breath, what in section 2 that defines personal data says that you must be able to identify a person, as particularly as you're saying, aren't just mere categorization sufficient? As my learned colleague has asked, isn't it sufficient that we are able to identify you as being within that particular class? Must we be able to identify Davis personally out of this room for it to amount to personal data? Can't we, isn't it enough that we know that there are 50 gentlemen in this room and there are 60 gentlemen in this 60 female, there are 60 women in this room? Isn't that sufficient? Where from section 2 do you read that very strict interpretation that for data to amount to personal data, it must be able to identify that person out of 1 million users?
Much obliged, my lord. Responding to the second question, section 2 in defining personal data states that personal data means information about a person from which the person can be identified. And so that is why I derive this strict interpretation, because it is clear that the person from whom this information has been collected is the one who must be identified when this information is produced. In response to the first question, my lord, when Facebook, in the event that Facebook and Instagram get a hold of data that describes my tastes and preferences, it will not suffice for that data being personal data simply because this data could be identifying 60 individuals in this room. As you may well know, the youths are fond of having quite similar trends. They follow what's on trend. And so if we're to follow the number of 21-year-olds that liked Adidas shoes, that liked eating at Cafe Javas, the number would actually be overwhelming. However, if this data somehow was enough for the person receiving this data to identify that this is particularly a Sime Davis Mugisha being spoken of, then that would suffice for personal data. But this data that would be sold to Facebook or whichever restaurant is in question would not suffice to identify me individually.
But where in paragraph 7 do you draw your conclusion or your assertion that personal data as defined under section 2 was not part and parcel of this sale transaction?
Much obliged.
Now, I don't want you to take us on some kind of presumptive fact. Where in paragraph 7 do you draw that assertion?
Lines 3, 4, and 5.
Indulge me.
The data collected through BrainBook was analyzed according to their personality, location, tastes and habits, their political affiliations, and financial spending habits. As per section 2, which I have continuously...
That is the processing, right?
Yes, my lord.
Now, I'm simply saying, besides processing, in this cell, at what point do the facts give you a legitimate ground to now say that the personal data previously collected was expressly...
Much obliged.
Because processing does not mean that you have now deleted the data for purpose sale. It's a standalone exercise which does not negate the fact that, as the applicants have asserted, that the personal data for the applicants was sold. We're not talking about what during the processing. In lines 3, 4, we're simply saying for sale purposes, the applicants have asserted, and they do argue, that the personal data was sold. We're not talking about the processing. You convince me that indeed there was a delay by design the personal data as you do claim. Just because I don't see that from the...
Much obliged, my lord. It is the respondent's submission that data was sold, and particularly not personal data, simply because actually information was sold, simply because the information that was sold is as a result of processing. Which processing? I mean the analysis that was carried out according to personality, location, taste habits, as the facts read. And so it is from this that the respondent submits that the information sold does not include the personal data of the data subject.
That's your assertion.
Yes, my lord.
Oh, okay. And just to loop in your fellow panelists, wouldn't that therefore leave me as the court a little bit in a sympathetic state of mind to consider the grant of the NPO order that was discussed in issue 3? Because then you're saying it was not sold, and I really, if I want to make a decision on the facts, I would want to be interested in knowing whether personal data was sold or it was not sold. I don't know, would you want to respond that, or would you want to loop in, maybe to loop in your colleague? Because then you have not convinced me that there was express exclusion by design or otherwise. And I'm now considering to actually grant the NPO order because I want to be very convinced, because this is the gist of the case.
Much obliged, my lord. It is my request that my co-counsel come and submit in response to that question.
Much obliged, my lord. I'm Wendy Kasemire, the co-counsel appearing on behalf of the respondents. And to answer your question, as I had previously explained, that a knowledge pharmaco order will be sought for purposes of evidence, which you have clarified. And I would also like to bring to your attention that there have been provisions that have been provided for under the Data Protection and Privacy Act.
As you're getting your authorities, yes, we're now in this court and the court will make its decision on all the issues. So don't go back into the issues of jurisdiction as your colleague had said. I just wanted you to address me or convince me. You have rightly stated that yes, NPOs are basically considered in the scheme of evidence. Now I am at cross purposes. You've admitted those personal data collected, but you now argue that it was not sold. They say personal data was collected, and they say it was sold. Isn't that something that the court would be interested in deciding, whether there was indeed a breach? Because you're saying there was no breach because there was no sale of personal data. And that really, if the court is to make a decision on the merits, I would be interested in knowing whether to grant the NPO order or not to resolve that particular issue. So I would like to know, convince me as to why I should not really exercise my discretion in favor of the applicants on issue 3, in light of what your colleague has tried to convince, but I am not convinced.
My Lordship, I thank you for bringing that question to this honorable court. To answer your question, as I previously stated, a knowledge pharmaco order is sought for purposes to attain evidence. Under the Data Protection and Privacy Act, in Section 5, it is stipulated that the role of the Data Protection Office shall be to monitor and investigate. The reason we as the respondents pray that you do not grant the applicants a knowledge pharmaco order is because there is an alternative remedy to make a claim, to file a claim to the Data Protection Office that provides the same role and has mandate to investigate and actually attain the information that they need. And to convince you further, my Lordship, I'd like to bring to your attention that the applicants have repeatedly said that there's been a violation of the law under Section 37 that makes it an offense to sell use of personal data. Me and my co-counsel have repeatedly said that there was no sale of personal data, and the distinction between personal data and data has been given. My Lordship, I'd like to pray to this court that if no violation occurred and no offense has been done under this act, then why should a knowledge pharmaco order be granted? Because the prerequisites to grant this order require that a wrong must have been committed, but we have proved that no offense or wrong has been committed, because Section 37 of the Data Protection and Privacy Act is very clear. It stipulates that Section 37 stipulates that a person shall not sell or offer for sale personal data of any person. My co-counsel went ahead to describe what personal data is under the mandate of this Act, under the interpretation 2 of the same Act. That was collected by Professor fit into the category that has been described as personal data in Section 2 of the Data Protection and Privacy Act, my Lord. To convince you, my Lord's Father.
Before you convince us, I want us to be very careful here. Do you understand what repurposing of data means?
Pardon your question?
Repurposing of data.
Repurposing of data. Is it provided for under the... No,
okay, do you know what
I retract my submission.
Okay, let me say the information. And you're alleging that all the data subjects were aware it was going to be used for, right? That information was collected. What is actually concerning us is you're mixing up the two things. Or the data was collected and processed, right? But then you're also using the you're using the same act to say that the data was not data information, and you're also using the same act to you're also using the same act to, is it 37 or something, section 37? To prove...
Section 37.
37, okay, to prove pretty much another point. My question is that if actually it wasn't personal data, why are you referring? Why do you want, again, justice under the same act? But that's pretty much aside. What I wanted to bring forward specifically was, if data was collected, right? It's collected, and then it was processed. The purpose, if I give you my data, I give you my age, my name, my location, my everything. Before I've given it to you, that is what I have given you to use for a specific reason. Before you process it, meaning you have collected it, you've gotten it from me. You can process it for many other reasons, right? You are required to ask me that, guess what? Or to seek consent before you reuse that data, repurposing. Reuse that data for something different. In your submissions, you said your life, because it's not based here, it was not practical for them to ask for permission or consent for from all the data subjects. Unfortunately, that is not the obligation of the data subjects. If you're in Ireland or New Zealand, if you're using data for Ugandans, you're mandated to follow the Ugandan laws. That is no excuse at all. You can't be in Ireland as like, oh yeah, I've got Ugandan data, and I'm like, well, I'm too far away to actually. You're supposed to go back to the person actually who sold you that data, and that person is supposed to seek consent if you're thinking it's not practical for you. So how would that even be a submission? Like it's actually legal. Otherwise, every international organization is just going to come here, grab our data, and pretend to not be able to access Ugandans. If you're able to access data for 20 million people, you should be able to access their consent, to get their consent if you want to repurpose that data. So whatever the data was collected and it was processed or repurposed for whatever you're saying, personality trace and all these things. But the data for the data subjects was taken for a particular specific reason. Then it was turned into a content, I don't know, a personalities, traits, research, or whatever they wanted it for. Why are you able to understand that, rather to differentiate between the two processes, the two actions? One, collection. I've collected your data, your names, age, everything, where you live and everything. But then, and I've finished actually carrying out my research. Now, if I want to process that data for another purpose, you're still required or mandated actually to go back to that Have you received emails from, like, let me say, either Microsoft or any most of these companies, whenever they update anything, whenever they reuse your data, because many times, anytime you download an app, right? You provide your data. You provide your data. It could be your age. It could be you provide your location. You provide your bank details, and they are mandated, that app, whoever is running it, to protect your data. But guess what? They could repurpose it and sell it to Jumia. Jumia, which is an online what they call platform that actually needs that information to sell to me products. Do you understand? But then I didn't give my information to Jumia. You have decided that the name, my bank details, whatever location, the information you had, you were able to process it and give it to Jumia. The processing bit. Because you could process it and give it to Jumia because it works for Jumia. Then you could process it, it works for Safe Border. So that Safe Border can send borders to my location every day. Then you can also process it and send and give it to a bank. You can process it but what we're trying to say is that before you process it and repurpose it for different uses, there has to be consent. I just want us to have that difference.
Thank you, my lordship. And to address your questions, just for clarity, I'd like to ask, you have asked us to give clarity on the collection of the data, the processing of the data, and what data was sold, and processing of the data for other purposes. Am I correct? To address your question, starting with the collection of the data, we have seen that personal data was collected with consent, and it has been clearly established by the Act. This is not an offense under Section 7 of the Data Protection and Privacy Act. We move to the part of processing of the data. There is no data collector that collects data without purposes of processing, and that's why, according to our facts, I'm speaking in context.
I can collect data for that particular field, or specific field, and then I could also process it for different uses. But the use, I collect data for one specific reason, then I can process it for different uses, which might be and that's where that's the explanation.
I believe that was a slip on my part in the facts provided for in this. I'd like my co-counsel to answer that particular question that you've posed to me.
We don't have time, but you've done very well, I guess. Unfortunately, we don't have time. Do we have any more questions? Do you have any questions to Adam?
My Lord, I pray that this court allows me conclude on the answering of these questions for just 1 minute.
Okay, we'll do it in the rejoinder then. Okay, let's just have a rejoinder for 2 minutes from both of you.
Much obliged, my lords, and at the risk of repetition, my name is Dalton Chisule, appearing for the rejoinder. My lords, you've given me 2 minutes. I had quite a lot to rejoin, but I'll just highlight the few. My lords, starting from my land brother's assertion that in Uganda there exists actually no class actions. I think he wrongly submitted before your lordships, and it is upon me, my lords, to refer you to the Human Rights Enforcement Act, Section 3, 1B, my Lord, which is to the effect that a person may institute a suit in the High Court in the interest of a particular group or class of people. My land brother seems to have mistaken that for representative action, because here we do not seek to represent the million others, my lords. We are just acting in the interest of the million other data subjects from whom data was collected, and it is our prayer that this particular decision by your lordships shall indeed have an impact of protecting the privacy of those million data subjects, my lords. Proceeding to the other head of our rejoinder, my lords, the first speaker, the first counsel for the applicants did submit on personal data, and he cited before your lordships the European case of Patrick Breyer versus the Federal Republic of Germany. It's actually reported at European Union Court cases, case number 779 of 2016. And in that particular matter, the court found that the use actually of personal information collected together with non-dynamic IP addresses led to identification, and that was amounting to personal data. The citation by my land brother actually further strengthens our position, my lords, because in the facts as seen at paragraph 10, even though there is actually no saving of passwords and usernames, it is actually a fact that when you bundle up all this information, location, tests and preferences, and you immediately log in with your password on that particular platform, you will be identified and perhaps an ad shall pop up. Much obliged. As my time is fast spent, much obliged, my lord. That particular logging in therefore shall establish a link between the information server system to your internet protocol and send to you an ad from the controller of the entity. It follows that whenever then the data subjects access, then with their logins, they're identified and their data commercialized. That therefore means that this particular data collected by the applicants leads to one conclusion, that there is identity of data subjects. My lords, lastly, I would like to address you on the assertions of my land sister from the respondents that no damages should be granted, and particularly the injunction, my lords. The respondents had only one duty, and that duty is enunciated in section 10 of the Data Privacy and Protection Act, and that is in their collection, control or processing of data to ensure the privacy of the data subjects from whom they collect data, my lords. The land sister did argue that in Uganda there exists no such permanent injunction, but I would like to refer my land sister and the court to section 38 of Major Plague, my lords. I'll yield the floor as my time is fast spent to my land brother here.
Much obliged, my lord. In response to the submission of the applicant concerning the case of Patrick Breyer versus Bundesrepublik Deutschland, it is very important to note that the submission of the respondent was that this case distinguished data from data, particularly because in this case, dynamic IP addresses were distinguished from static IP addresses, which further strengthens our argument that the data collected did not suffice to be, that the data sold, the information sold by Your Life to Infinity Analytics does not suffice to be personal data because it could not pinpoint individual data subjects. Secondly, my lords, on the submission of the applicant in regards to the NOIC pharmaco order sold, it is our response that the applicants have failed to prove the damage that they have suffered under the actions or by the actions of the respondents in this case, which forms a pertinent prerequisite for this order to be granted. Thank you very much.
Andy. Hi everyone. Hello. Good afternoon. Sorry for the delay in lunch. If everyone could get food and then come back here. We have a short session. We need to take place now. Everyone, please come back as you get food. I'm Wendy Lucy, Jumba Senteza from Somba Solutions. I'll talk about that later. We also do tech. Right now I'm going to introduce analysts. So we have Edgar Kuhimbise from an order. Edgar, you could wave a little bit. And then we have Rita Ngenzi from Youth Startup Academy. And then one left because of time. But then we also have Arthur Mukembo from Innovation Village. And lastly but not least, Kaleba Aaron from Stanbic, that's FlyHub. So these are supposed to be our panelists. We're going to cut this short. I'll just introduce them briefly, then they'll talk about it. They'll talk about themselves.
Yes.
Okay. I'm just going to introduce you briefly. Or do you want to dive into?
Yeah.
Okay.
So thank you. I'll just dive in because of time.
No worries.
Unfortunately, we've run out of it, but I'm sure we're going to share information on what will happen going forward. So, the national coordinator for the Youth Startup Academy, ITC. The ITC is the International Trade Center, which is a joint agency of the World Trade Organization, and its mission really is to foster sustainable economic development through supporting small businesses in developing countries by really focusing on sustainable, inclusive, as well as digital trade.
Okay, that's Rita again. Next I'll have Arthur Makembo from Innovation Village. Jenny. Is it working?
No, the app wasn't responding. No. Great. Good afternoon, everyone. I wish I knew at least 2 or 3 of the technical terms I've had today, but it's a pleasure to be here with you all. I hope the lunch is going well. My name is Arthur Mukembo. I lead the Future Lab studio at the Innovation Village. The Innovation Village is essentially a place where you come to bring your ideas to life at whatever stage they've gone at. Through our different interventions that we provide there. We are very passionate about empowering young people to get their ideas into the market. On the Future Lab side in particular, what we do is we work with those who are building tech or tech-enabled solutions, whether you're a corporate company, whether you're a founder like yourselves in this room or whoever it is. If your idea can solve a systemic issue in society, using technology, we have different pathways that we can put you on to develop it, to scale it, to get investment for it, and for you to really impact the communities that you intended it to reach to. I think we'll be unpacking it a little bit more as we get to chat, but it's a pleasure to be here, and I'm very impressed with the quality of debate today. Thank you.
Thank you, Arthur. Next I'm going to ask Aaron from FlyHub to speak. Briefly.
Good afternoon, everyone. My name is Aaron Joel Kaleva. I work with Stanbic Uganda. FlyHub is our technology subsidiary, but I advise the group on technology, corporate finance, financial services regulation, and corporate governance. FlyHub is an important subsidiary for us as Stanbic because it's at the forefront of a digital transformation strategy, and it is our hope that through partnerships like this we can be the pioneers of using technology to change our societies. So we are excited to be here, and yeah, I was a Moot myself, still a student, so it's some bit of nostalgia, especially in emerging issues like technology. So it's a pleasure being here. Thank you.
Thank you. Thank you, Aaron. Lastly, we shall hear from from Arthur. Edgar. Sorry, Edgar.
Hi. Thank you. My name is Edgar Kwimsa. I'm from the Justice, Law and Order sector. That is in the Ministry of Justice and Constitutional Affairs. I'm a technical lead on e-justice and digital transformation. My job is to coordinate the digital ecosystem as far as access to justice is concerned, working with the judiciary, that's the courts, the police, the DPP, I'm sure all those, everyone here. My job is to coordinate programming and also innovate and create ideas and solutions that improve access to justice for ordinary Ugandans, and I'm excited to be here.
You're excited?
I'm very excited.
Are you staying?
Yeah, I know.
Okay, so in respect of time, the panelists have begged to be excused. So if I get this right, Arthur, you're hosting us. I need to put this out there.
I like that, yes. I think we will revisit an opportunity to have a much deeper conversation with the team.
Okay.
But yes, we've, at least from our perspective as the Innovation Village, we've been proud to be part of this discussion, part of this activity. It's very important. I'm surprised to find out today that this is optional. I think, yeah, right. The recommendation would be if the different universities, maybe the law council, could adopt this as a requirement in their curricula for people to have this kind of experience. For me, that would be a good win. It's also to encourage people. The two things we're very passionate about at the village, from a legal perspective, we have. Oh, sorry.
It's okay.
No worries. We have
just 1 minute.
No worries. A practice called the Legal Tech Lab, and in there are two things that we're passionate about: access to justice and building the law practices of the future. So you being involved in a conversation like this tells us that there's promise for transforming some of these things. I'm really looking forward to a deeper conversation where we'll unpack this and see where the opportunity is, what's the career opportunities for you as well as young lawyers, and then how can you be more actively involved. Looking for.
Thank you, Arthur. The panelists can be excused. You can have lunch, the ones that are still around. I'll call upon to okay, you can be eating. Ivy is going to come and present.
that avenue. And the guys giving us food, so many service providers came through for this. I would like to welcome our distinguished guests, guys from Barefoot Law. Thank you for showing up. We have presentations coming up, but briefly, I'd just like to say thank you so much. Thank you for coming. The students who escorted the teams, rounds, usually there are fewer rounds than those, but that was for the purpose of having each team present so that there is no room for doubt. So you had 4 chances to show your work. Thank you so much. The idea of the Moot really is to foster innovation from the ground up. Law students play a big role in this through the ideas that are shared in these moods. But even in practice, you will find these ideas and students to find this a strange practice. Technology and innovation is a very upcoming area of practice. So we wanted you to have a thorough experience of what it's like. I know the judges were quite rough on you, some of you, but that's how the field is. You get it right the first time. And we hope you benefited so much, and we hope to do this again next year. And thanks to the judges who did the finals, such a great job. I can see Miss Diana and Alice and Paul. Thank you so much for this. We're going to have an award ceremony in a few, but simply thank you so much. Hope you enjoy your lunch, and let's do this again next year. Thank you.
Hear our prayer. We are your children, and we've gathered here today.
Hello. Ladies and gentlemen, we would like to welcome back our judges. Thank you very much for making it today, for sparing your precious time. We do understand that you're very busy people, but you took your precious time out of your busy schedule to attend to the law students. We do appreciate you for that. On that note, our judges are going to give a few remarks in respect to the moot and any further necessary communication they might want to give in respect to the participants and the winners of the moot court competition. Thank you.
Good afternoon, participants. I want to take this opportunity firstly to appreciate each and every team that has been part of this Moot court competition, the first of its kind. In a special way, I also want to thank our finalists who have graced us with very wonderful presentations. I must admit that I have learned quite a lot, not just today, but through that we've had this Moot court competition. Specifically, I would like to advise that moving forward, it is crucial as you prepare to make your presentations to ensure that you're well researched in the relevant areas. Many of the questions that you were asking were really quite obvious for someone who has been conducting research on this area for a while. The second point that I would want to make is that ensure that you assist each other and you prepare together. That most often helps you to come up with a balanced presentation. You don't want one participant performing extremely well and one participant performing poorly. That tends to reflect badly on the team. So research as much as possible and ensure that you have balance. That's really it from me. And I would like to congratulate you once again. Thank you for participating in the competition, and I hope that you eventually, when you're called to the bar, take interest in this area of the law and you actually pursue matters in this area. Thank you very much.
Allow me to congratulate all the teams that participated in this particular moot, and also for the finalists, the teams that made it to the final. It must be hectic, and it must have been quite a taxing exercise for you. Let me just say that your performance in many ways was excellent, really, really excellent. And I hope you'll get, even if despite the fact that you're holding plates, you can still clap for that. Your performance was excellent. I think as law students, it's the caliber of arguments that we would expect from you. I think that you are going places. I watched, of course, with keen attention to particular people, and I know that if you keep at this space, you will be excellent in the legal field. And so don't look down on yourself, don't shy away, don't back down. I think that the performance as a whole was really good. And I think a comment similar to the previous judge is that teamwork is really important. Teamwork is really important, and you're only as strong as your weakest link. And so it's important that you are uplifting one another and ensuring that you are performing in tandem, not just the one person that stands out of the team, but everybody in the team needs to stand out for you to excel. With regard to the substance of the law, I didn't expect so much, so I congratulate you on doing your best in that area. Thank you.
I would like to join my colleagues in congratulating all the participants, including those who didn't make it to the finals. The finals could not have been possible had it not been for the participation, hard work, and commitment of all your teams. But for the people who participated in the finals, I would like to really congratulate you all upon your very wonderful participation and competition. Shortly, we shall be announcing the winner from the collective assessments by all the judges. But it's important that we understand that this is a moot competition, and it's really not about a competition that is intended to decide the merits, but rather to give an opportunity to the participants to really enhance and develop their skills, legal skills, oratory skills, and other relevant litigation, and even just research skills. And on that front, I think you all did exceptionally well. Of course, we do understand the limitations that moot competitions always present, especially when there's only so much that you can do as far as stretching your facts. And sometimes that limits you, or limits your arguments, or limits your research, and sometimes you find your hands literally tied. But nevertheless, those weaknesses notwithstanding, I think you did commendably well, And I would like to really encourage you, like my fellow panelists have done, to encourage you to really keep on learning, keep on researching, improving your oratory skills, research skills, presentation skills. And one of the things that we noticed, I think from our collective assessment, was, there's always that temptation to cram. And we saw in posing certain questions, some of the presenters would tend to become stuck because maybe you were biased by a certain line pattern or a line thought, and you've suddenly been thrown off balance and you don't know how to really coherently, make a response. But again, at least I don't know how my fellow panelists are. Some of these opportunities to really, develop your presentation skills through these competitions, some of us never had. And where you stand, like my fellow panelists has stated, you're in a much better position than some of us were. And definitely if you continue at this, you will be in the next years, shining stars in the different in the different engagements or jobs that might be privileged. Of course, I hope you'll join many other lawyers, immense knowledge to be made, and that's one thing that lawyers always love to hear. So, but for you to do that, to excel, you really need to stay hungry for knowledge, to stay, inquisitive, and to most importantly be a good lawyer, one who researches, one who can make their case, one who is caught when they're given an opportunity to speak, and one who leaves their clients really happy and convinced that you know what you're talking about. So again, congratulations to everyone, and to those who have won or who will be announced as the winners, congratulations. To those who may not be the winners, you are in the best position of your learning lives. And this is really not by any means a judgment of your abilities, but it's rather, as we unfortunately have the burden of making, we have to decide who passed a certain tests according to the yardsticks that we have to use. But congratulations.
Thank you. We are speaking, but we are missing the respondent, the applicants and the respondents. Where are they? Oh, okay. You're having a snack. We were told you're going for a snack, and we found you're having dinner. So, it's okay. And your colleagues? Oh, okay, fair enough. Yeah, I think both teams, you did very well. That was a brilliant performance. I have a few comments. I just realized all of you guys had crammed, right? You are not even actually looking through your notes or something. This is something, there's a danger to that. Yes, you have all the information, but there's a danger to that. When someone asks you a question of what you have actually crammed, then you start, you understand, it's also easy to lose your line of thought because you've just crammed everything. Try to understand what you're submitting. So, like for example, is what you're submitting about personal data and all these things. Most probably you caught this phrase somewhere and said, okay, this is our argument. But you didn't go back to really understand the whole line, of argument, because there was, what I wanted you to first understand, how was this data collected? The information that you had, the facts had, it all started from personal data, right? Personal information that was being processed. But then you just came up with a phrase and hinged on that. When you were asking questions around that same issue that you had not actually prepared for or cram, but if you've understood something, it's so easy for you to go back and forth. Do you understand what I'm saying? So try, I don't want to blame you. One, it's just the way we have always been taught. You just cram your way throughout school. But try to understand this, that in the job market now, people don't want any cramming. They just want you to actually understand what you're going to do. And in case of any questions, around your job or work, everyone expects you to be able to have some kind of creativity in everything you're doing. So please, both of you, both teams actually had that same problem. Then the other thing I thought, especially, I think for both parties, you're talking about something in a digital space, right? But everything of yours was on paper. How do you prove a case without, now you're bringing up a screen? All your evidence, you could present it. If you're going for this kind of similar competition, this is how you stand out. If you're going to another university now, or maybe another country, bring out digital evidence and say, this is actually what happened. This is, you understand? You're in the digital era. Use that information. Again, you went into expert evidence, right? You could have actually just come up with a report from a data analyst. This is how now you learn. You go to a data analyst and make you understand these things. Apart from just, you understand, cramming something and they're like, yeah, let's find the law, and then things are contradicting. Go to seek advice from people, what they call it, technical experts. Your case could have been argued very well if you had actually the technical knowledge, but you didn't. Do you understand? I'm sure you were just reading, I don't know, but you're also not taught these things, so you did actually well. So yeah, to have a twist to something, especially in the digital era, I was very surprised that none of you had any digital evidence. But anyway, I hope next time we'll all do better. Thank you very much. So we'll have the final results. We're going. Sorry.
The moment is here. So I've been delegated by the lead judge to make the announcement. I don't know whether of good news or bad news. I will request the lead judge to go to the front of the podium, and I'm going to make different awards, or to announce the different award winners, starting in no particular order. But I would like to announce, and just before I do, these results are a result of a collective computation and tabulation from all the previous rounds that were undertaken between all the teams. And so some of these awards are really a cumulative assessment throughout the different rounds, the preliminaries, the semi-finals, and the finals. So I would like to announce the best female competitor, or the best female lawyer, oralist, or whichever description you'd want to give. But the best female participant in this year's Take Moot competition is Naiga Tracy. Please come forward and receive your award, or from congratulations, Tracy, and congratulations to all the ladies who participated in the competition in 2022. The next, the best male oralist, presenter, participant, or competitor is Dalton Chesule. Congratulations, Dalton, and congratulations to all the male participants in this year's competition. Now, the next award recipient is the overall best speaker, and that is Mariam Lawoko. Congratulations, Mariam. It seems you have a good fan base. The next is a team or collective award, and that is for the overall best memorial that was filed or lodged. And that award goes to Makerere University. And now finally, the winning team. Now, maybe before we do, we announce the winning team. I would like to just give in 1 minute. Just to maybe, Chair, maybe you could first resume your seat. Yeah. We'd like to just give the reasons why we made this decision to award the winning team mark to this particular team. And we sat down as the panelists, and we were, of course, the management team or the organizing team had given us different criteria. Key among them were the need to really assess you on your grasp and understanding of the facts, grasp and understanding of the law, the overall presentation, and the general and other attributes, and also the way you're responding to the questions that the panelists were posing. And without really going into the nitty-gritty, we made this decision based on our awareness that, one, this is a moot, and we are therefore constrained in making a very comprehensive or detailed decision on the facts because of the limitations that you understand and you are aware of. However, we nevertheless had to assess you on your knowledge of the facts and how you applied them in your arguments and the ease with which you really would maneuver around the facts during the course of your presentation. But overall, we made the decision based on, of course, that being one of the key considerations. We were also minded of the need to assess you on the overall, the coherence of your arguments, the clarity of your thought process, and the consistency in the presentation between the two presenters for, representing each team. So we also had to evaluate not just the team as a whole, but the individual performance, and to give it a weighted kind of evaluation. And from that collective assessment on a 4-to-1 decision, the judges, first of all, we were asked to wait for one of our sponsors who's, okay. So now that he's here, allow me again to announce the winners, the overall winners of this year's Tech Moot competition. On a decision, split decision of 4-1 goes to the applicants. So congratulations to the applicants, but most importantly, congratulations to the respondents who were really excellent in some of the attributes that we had to consider. Just to give an example, the knowledge of the facts and the manipulation of those facts in the application to the law was excellently done by the respondents. So congratulations, you are winners, and you will continue winning if you continue in the same path that you have started on. So thank you. On behalf of the panelists, I would like to invite the lead judge to go and award, together with the sponsor, the CEO of Flyby, to give this award and trophy to the winners of the competition, the applicants team. Okay. Thank you for the guidance. I hope I'm not hijacking the MC's job. I would like to request the respondents, right? No, they're not losers. They didn't win. I would like to invite the respondents, the first runner-ups, to go for a photo opportunity. I think also they have medals, yeah, to receive their awards and medals for a job fantastic, for a job well done. I see David seems to be, the mood has gone down, but that's the spirit of champions. And the lady is reminding me that he's a gentleman. I don't know. But congratulations to the respondents team. A photo opportunity, maybe you could just have. We need sponsorship from FlyHub next year, so we really need to give some accountability. Once again, congratulations for the great run up to the finals, but there can only be one winner. Not that you lost, but we had to make the hard decision. And finally, I would like to invite the winning team to go to the podium to receive their individual medals and the overall team trophy for the fantastic job. And congratulations to the applicants team. I think my talking bundle has expired. And I would like to thank the organizing committee for the job well done for the last 2 days and for the days leading to this event. I think you all deserve loud round of applause. So thank you.
Thank you very much, Mr. Augustine, and to the rest of our judges and our sponsor, Mr. Joe Momusa. We really do appreciate the time that you took out to attend the Tech Law Moot Court competition. By the way, the first of its kind. We really do appreciate it for the knowledge that you imparted into the students. We are truly grateful. On that note, once again, I would like us to really give a round of applause to Makerere University, because I really did not hear you guys clapping your hands. So please, louder. Yes, thank you very much. Congratulations, Makerere University. I had been following your submissions and both UCU. I just didn't know the institutions, and your submissions were truly brilliant. On that note, we're going to dive into the next segment. Thank you, our judges, for attending. We're going to dive into the next segment, and I'll hand over the mic to my co-MC, that is Wendy.
Joel, sorry, I'm going to have you back here. Like my colleague Ivy said, hello, I am Wendy. I introduced myself earlier. Like Ivy mentioned, we then now have the sponsors and some of the partners speak to you. This is an opportunity to understand what they're all about for the future prospects. This event was organized by Center for Technology Disputes Resolution, that's CTDRU. I'm sure you're all familiar with that. And it was sponsored by FlyHub, Innovation Village, Somba Solution Store, Alp East Africa, in partnership with WAPE and Tube. So I will ask Joel, before you go, to speak on behalf of FlyHub for probably 3 to 5 minutes.
All right, thank you. Someone said clap for him because I'm paying you guys. I won't speak for too long. I guess I'll just tell you guys what Hello? Is there Hello? Yeah, now I sound cool. It was that mic. So my name is Joel, and I'm the CEO of FlyHub. FlyHub is the first technology subsidiary under Stanbic Holdings. So when you hear Stanbic, I think you think of the bank, but as of 2020, it's a holding company, so it has a real estate company, it has a securities company, it has the Stanbic Incubator, which supports small businesses, and FlyHub, who were created really to be a technology subsidiary, and I was hired to provide direction there. When I was reached out to by the team organizing this, I thought it was pertinent for me to support, because the direction that we're going in is becoming a data and platform business. That just means we're going to be running the platforms that the different Stanbic businesses are going to be operating in to begin with, and then also building platforms for our economy and more broadly in East Africa. So the kind of cool stuff that we want to do with data, involving automation of different workflows, being able to pull out insights, those are the things that are going to be my bread and butter, and so the discussions here today are quite pertinent for that. The only thing I'll say to you guys is when it comes to technology, I know I've worked in it for a while. Often people think it's something neutral. People think it's something that doesn't have, I guess, intentions behind it. But as you guys start out your career,
you have the chance to develop the rules and the way the game is going to be played in not only Uganda but in Africa. For the most part, we've adopted different roles, different ways of being from other parts of the globe. But in this arena, there's a chance for us to be the ones to redefine the game. No one else is going to do it but you, my learned individuals. I keep hearing lawyers saying that before they abuse each other. They say, my learned friend, and then they show you're not very smart. But my learned individual friends, if you have any interest in that arena, FlyHub is located in Kololo, plot 5. We're always welcome to have people who have good ideas, smart things that you want to try out, because we don't have the answers, but we want to work with people who have good ideas. So if you're interested at all in the platform economy or in data and artificial intelligence, we are the guys for you. Thank you so much, and enjoy the rest of your day. Thank you, Wendy.
Thank you, Joel. Do you have any questions for Joel before he goes? Okay.
Just a small announcement. There's someone who has parked their car at UBM. It's blocking another car that is trying to move out. So if you own the car, please do the needful.
Okay, so next we shall hear from ALP East Africa. I'm going to introduce the lady to you. Okay. Okay, sorry, pardon me. Before TG comes, we're going to hear from the host, Mr. Godfrey Arianga, Cavendish University. Please clap, because he won't come up.
Because the headache, now currently massaging. There is something I ensure that you're all happy. As I can see, Makerere excited to wear the trophy that was prepared by Cavendish. That was a joke, okay? So, good afternoon, ladies and gentlemen. Again, my name is Godfrey Airanga. I am a lecturer at the faculty, but I was also your host. And I speak on behalf of the dean, who, for reasons beyond her control because of work, she's unable to make these remarks. But she asked me first to thank each and every one of you for having showed up. So you want to clap for yourself? I think you want to do it again. Let's clap for everyone. Next, I would like to specifically thank the Center for Technology and Dispute Resolution in Uganda for making sure that this activity was a success. Let's just clap for them. I also want to thank specifically the Moot coaches. Let's clap for them. The Moot coaches, just stand where you are. The Moot coaches. Just stand, please. I see Ivan. Just stand. Okay? I want to thank you very much for ensuring that this competition was not just a competition of its own, the first competition, but it was a competition worth attending for those who paid for the tickets. Okay? Thank you very much. I also want to recognize the judges. I mean, you made sure that this was a competition. I don't know if I can see any judges around. But in the absentia, let's just clap for them. In the absentia, they made sure that some individuals were asked for water at a certain stage. That being said, I want to thank each and every sponsor. I can see we have the Innovation Village. Let's clap for them. I see we have Somba Solutions. They made sure you had the internet, by the way, if you don't know. Okay? We have Barefoot Law. Just clap for them, please. Again, let's clap for them. I know you're tired, but we are ending, okay? I know you're tired, okay? And then, I want to just specifically mention that, let's just clap for the finalists, just to appreciate them also. Now, having said that, I think you also want to clap for me as a host. Just clap for me.
Please clap.
Thank you very much. Now, having said that, I want to thank each and every one of you. And one thing I want to promise you, and as already said, is that every time there's a moot competition, ask yourself one question. What is one thing I take back home? I could have lost on a final. What is one thing I'm taking back home? How do I better myself with the information I got from today? This is technology. What is it I'm taking back home? Is a question I'm leaving for each and every one of you. That yes, you won the moot, but what are you taking back home? Do you understand? So I'm also a teacher, unfortunately. So I pray that each and every one of you will go home safely. And my plea is that you feel free, as and when you can, to always visit the premises of Cavendish University, Uganda. We shall always welcome you. I see she's excited. But I want to request that anytime you feel you want to approach the premises, if you just say a muta, we shall always have a place for you. And my plea is that if next year they give us the moot, next year, we shall invite you again. Thank you very much.
Thank you. On that note, I'll invite ALP East Africa, Miss Latigi Fiona. She'll speak to you for 3 to 5 minutes. Please indulge her. Ask as many questions.
Good afternoon, everyone. My name is Latigi Lamara Fiona. I work with ALP Advocates, ALP East Africa. We are a regional law firm with branches in Uganda, Kenya, Tanzania, and just recently South Sudan. My discussion was supposed to be on intellectual property, but you guys seem to have already sensed that. You might have that knowledge already, but also since we have moved the panel discussion, this presentation is going to be moved to then. It's about understanding intellectual property in innovations in the digital era. But just why we came up with this presentation was because when we listened to the moot discussions and arguments, we saw that, because working with CTDRU, we noticed that most of you had missed out on the argument that Professor had made his own app. He had made his own copyright, and a lot of you had missed out on that. The fact that he had developed new ideas and created different formats and new, what could I say, there were those, he made up a new kind of algorithm and all that, and those were kind of new intellectual properties that were not really brought up in the discussion. We felt that there was a gap within the just understanding what intellectual property rights are around these discussions. So that's the purpose of this, that's the purpose of my presentation. But I don't know if I could actually go through it now, or wait till later. But I could just give you just a brief. For innovation is just like it's the new thing, to be honest. Margaret Vesta of the European Union said there are only 2 types of businesses: those that are digital and those that are soon to be. And I love that you guys are in this field and you're taking part in technology moots and you're taking part in technology. That's a field that I am particularly interested in. And I'm glad that many new people are actually here and participating in technology moots, and you have actually researched and done a lot of, you have very good arguments on these points. And I really appreciate all your efforts that you put into the research, and your arguments were really, really good. And I would appreciate it. I want to thank all of you who participated in this moot and brought out your arguments. They were amazing. In continuation, I would be glad to give any of you who is able, who is interested in tech law, I could mentor you. You can reach out to me and I can talk to you. Okay, I'll select you, yes. You'll find me and we can talk. But if you want more to know about this area, if you want to research more, I just advise you, just for the future, is that you should research more. Read the laws. I feel like with technology law, the laws are there. They are strict and they are there. But the problem that comes with them is that what's in Uganda, our technology law in Uganda, is kind of different from technology law elsewhere because they are more advanced and they have gone further ahead before us. So I advise you that as you do your technology research, as you enter into this tech field, do more research even out of Uganda, because us, we are a bit limited, but it would broaden your mind. You'd get to know what artificial intelligence is, because yes, we are growing into the field. It is new. We have maybe people in the IT world doing it, but there are few lawyers who are actually invested in knowing what is artificial intelligence, how can I protect someone who has created their, let's say their app. If they have created their app and they have made their ideas, how can I protect them? Yes, the people of the technology might know that, okay, this is my investment, I want to make money from it, but your role as lawyers is to come and show them that, okay, you know what, you've made this, but it could be stolen from you, it could be taken away from you, or even in you developing your app, you could infringe someone else's rights. So in this process, your role as lawyers is to come in and help these people in technology world, because they don't know the law, and then us, we also don't really know so much about the technology. So we work well together, and I believe if you engage so much, in the audiences, there are so many people who are doing technology. I saw the Fly Hub people. I didn't see any of you engaging with them though, but you should engage with such people and get to know what they're all about. There's someone here who is in artificial intelligence. He's there, it's called Jonan. You can talk to him. He's going to talk to you later. And you can engage him and know where can we help you as lawyers, and where is the gap, because there's so much that is missing. And it's very important. It's a very important area that needs to be protected. There's a lot of data, there's a lot of copyright, intellectual property, patents, designs, which have not yet been uplifted as a country. People are not protecting their design. Someone comes up with a type of, someone comes up with a shape or something that is new, for example, for their machines and all that, but they don't protect them. We have people who have come up with new ideas, come up with new apps that are even very innovative, more than even the ones that are in other countries, but they would leave Uganda and go to all these other countries to develop their apps, when as lawyers we could actually help them here. So just to conclude, I will not really go so much into my discussion of the different copyrights and the different IP rather, sorry, but I would encourage you to continue reading. I could share my presentations with any of you. If you have like an email or something, I could share my presentation that I have made, and also invite you for the panel discussion, as well as when we shall be discussing different digital innovations, the intellectual property that involves it, when we have the panel discussion, and I would invite you to come and attend and listen to all the great ideas that would be there. Thank you very much.
Thank you, Fiona.
Thank you very much, Fiona, for showing us the connection between intellectual property and in digital innovation. I think this will be very helpful information for the students. In respect to mentorship, information is just coming to me from our sponsors, that is in the Innovation Village and the Legal Innovation Hub. Now, it has been said that all the participants in the Tech Law Moot Court competition have been offered mentorship from the Innovation Village, and they will be contacted. This will be mentorship that is in relation to the aspects of legal tech and digital innovation. Then particularly to the winners, the Legal Innovation Hub will also be offering special mentorship to them. So we have Innovation Village offering to all the participants, and the Legal Innovation Hub, which also sits at the Innovation Village, offering special mentorship to the winners, that is Makere. Let's give them a round of applause, please.
Yay!
But you guys, I have a problem with that you don't clap. Please give them a round of applause. Huh?
We have more Cavendish participants. Okay, so I also want to add on to that note that you're all going to get certificates, so please clap. And please stay around so that you can get them from your different coaches. Next we'll have Somba Solution Store speaking for 3 minutes. This will be done by Miss Peace Akao. Let's clap for her as she comes, please.
Wow, thank you very much, Wendy. My name is Peace. I'm here to speak on behalf of Somba Solution Stores. Now, congratulations to all the participants. When I was growing up, my desire was to be a lawyer. So when I came here, it brought back all the memories that I had. I remember I used to go with my dad to hear the court sessions and all that. So it brought back all the memories. Thank you very much. I respect you guys. Yes, so talking about Somba Solution Stores. So basically what we do, I think most people know us for internet, but lately we are moving on to cybersecurity and cloud solutions. So cloud solutions is in terms of Microsoft and Google and Azure and all those things. So you can contact us in case you have any of those needs. And when you guys are making your submissions, I'm sorry for using slang. When you guys are making your submissions, what stood out for me was that there is need for cybersecurity. And at Somba we also deal with cybersecurity. So as lawyers, there is need to protect your data. There is need to protect your client's information. So we also do that at Somba Solution Stores. Is there any question? Okay.
Are you sure you don't want to ask if there are openings?
So in terms of internet, we provide internet for offices and homes and all that. So we've been around for I think for about 7 years. Yes, for 7 years, since 2014. Thank you very much.
Thank you, Peace. Next we'll have Justice Board, which is a legal entity. We'll have John and Katende speak about it. It offers tech solutions and protection in that regard. Please clap for Jonan.
Hello everyone. Congratulations to the winners. My name is Katende Chonan. I'm very happy to be here, and I thank the center, CTDRU, for inviting me and giving me this opportunity. I'm very passionate about the law. I, at one time, thought I would become a lawyer, but I'm very glad I never managed to become one. After what I've seen here, a lot of discussions back and forth, but I'm happy that I run an entity that complements the value architecture map in the justice, law, and order sector. So Justice Board is an organization that is registered in Uganda, running operations in DRC and Canada. We have automated online platforms that utilize artificial intelligence to provide legal information, connect people to lawyers, and come up with innovative tech solutions in the same industry and sector. So currently we have chatbots that are configured with Facebook Messenger. They provide legal information in simplified text to people. We basically simplify the law via text and infographics, and then distribute it to different people across social media platforms and the digital web. Then we also build different systems. We have been in talks with JLO Secretariat to see what we can do around predictive policing, building models that can monitor crimes, building models that can predict cases. I want to call on all of you guys actually to take interest in artificial intelligence, in automation. For us to believe that the future holds for efficiency and convenience, and therefore we come up with automation for fast and efficient service delivery. If you look around at how the industry has changed, time is the new luxury. That means that people are more willing to pay for spending less time. So if you can automate some of your processes, that is actually the future, and that is where we are going. Efficiency simply means optimizing and saving time for consumers and setting the stage that simplifies their everyday life. So all companies can essentially incorporate that into their value architecture maps, and I think all of you here are potential innovators in this kind of industry. The industry is too huge. I mean, the problem is too huge at CTDRU, barefoot before. There's a lot of innovations in the sector. However, there continues to be gaps, there continues to be problems. So if you take interest in that kind of line, I think you're going to make it out in the field. There is a company in Canada called Blue Jay. It's one of our competitors. It has a system that predicts cases to do with taxation, and they have a 95% accuracy. These are some of the things that I think lawyers could take interest in. There are things to do like the personality. We're speaking at the Africa Tech Law Conference this year in Nairobi, and one of the issues we had was that the personality of artificial intelligence in the business of law has not been defined. So I think this is something that you can take interest in. In Estonia, they're using robots to decide on cases. The question is, on what basis is this robot giving a verdict? Why has it condemned me to go to jail? So these are some of the things that aspiring lawyers can actually look into and help us that are trying to build solutions and systems in that regard. So I think that is it from me. Have a nice time, and you can always reach out to me in case you need anything, in case you need any help, any advice, business-wise. That is what I do. We actually have a partnership with there's an organization called Utopia. It's in the UK. We have a joint venture that runs across East and Central Africa. So in case you have a solution that you think needs to be scaled in that regard, you can actually reach out to me. And for those that are particularly interested in business, you can also reach out to me. There is a lot that we can discuss across that line. Thank you so much.
Thank you, Katende. In perspective of time, I just have two more sponsors. We shall have Barefoot Law. They will be presented by Mr. Ivan. Ivan, please come.
Thank you very much. Ivan is a good name, and I believe my colleague, who is a coach to a team, has left a good impression. But my name is John Kennedy Kasozi. I'm a lawyer and advocate of court. I'm a project and partner relations manager at Barefoot Law. Barefoot Law is not a sponsor of the day or a sponsor of the event. We're collaborators with organizers of the event. And first and foremost, we'd like to thank you for having invited us to come and witness the spirited arguments of the day, as well as see the evolving trends around technology and the questions we should be thinking about as members of the legal fraternity. Secondly, we'd like to appreciate the Mooters. Some of us, when we were in law school, we did the same, and it's good to see that the spirit is quite engaging from the various universities. As Barefoot Law, we are a non-profit legal aid organization that provides free legal information, guidance, and support. We do this because we believe, first and foremost, as lawyers, we're the custodians of the law. And as custodians of the law, we have a role to play in ensuring that the law is used to resolve dispute. You may ask, as opposed to what? As opposed to people resorting to avenues such as mob justice, such as revolt, such as boycotting, okay? So it is our duty, first and foremost, to inform the public as custodians of the law about the law itself that governs them, and so that they may not fall in an ambit of saying they did not know a legal provision, and therefore they would like to plead ignorance, which you know, obviously, ignorance is not a defense, right? In the same way, we believe that by facilitating and availing legal information, we support efforts that facilitate access to justice. What we do as Barefoot Law is aimed at educating, empowering people, and facilitating enforcement of rights. So we are happy that as a community of practice, the justice innovators community is continuing to see that there's innovations around the legal system and legal industry that avail information, avail answers to legal questions, and empowers people to enforce their rights. And in the same way, we applaud the organizers and pledge our continued support and collaboration. as innovators in Uganda. In an interesting way, Barefoot Law is one of the few pioneer organizations who are using technology and ICT to provide legal assistance. And we are currently also shortlisted in a campaign. Some of you may have heard about it, some of you are yet to hear about it. We were shortlisted in a campaign of organizations and innovators doing something that contributes to the benefit of the society. And the campaign is called Uganda Needs More of You. It's an Airtel campaign, which we're participating in, and we are available there to create visibility of our services, not only for people to find us on the various social media platforms, which is Facebook, where we're known as Barefoot Law as Uganda, Twitter as Barefoot Law UG, and the website and social media such as Instagram, but also to create visibility for people to know where they can find legal information to guide them. So we'd like also to call upon and request your support. As people are interested in legal tech and fostering legal tech, if you have an Airtel line, you can dial *162# and select 2. We're the only legal innovation in the shortlisted campaign. The other competitors include a farmers app and another app which is regards to providing medical assistance for people suffering with TB. But since we're talking to the people who are here and are interested in furthering legal technology, we call upon you to also consider voting for us. Remember to dial *162# and select 2. Thank you once again for inviting Barefoot Law, and congratulations to the finalists and the winners. Thank you.
Thank you so much. Lastly, we'll have a short presentation from WAPE, and we're going to have that done by Miss Natasha for about 5 minutes, because we need to award certificates after this.
Hello everyone. Good evening. My name is Natasha Katondwachi. I am a co-founder and team head at WAPE. Here with my team, Basil, Daniel, Rona, and Collins. We're very privileged to be here. I'm also privileged to be an alumnus of Cavendish University from the Faculty of Science and Technology, and I would like to thank the management of the university for hosting us. We're also very privileged as WAPE to be partnering with CTDRU on organizing this technology law moot court competition, and I'd like to congratulate everyone that has participated and those that won the competition as well. Just to tell you something brief about WAPE, within the next 30 years, there's going to be a major shift in the world that very few people know about. A quarter of the world's labor force is going to come from only one continent, and that continent is going to be Africa. So currently there are so many projects and institutions that are running upskilling program in the digital space, but very few solutions for what happens after these individuals have been skilled. So at WAPE, we are trying to revolutionize the way hiring is going to be done in the next decades, and we are creating an infrastructure to define the hiring across Africa in the next decade. So what we do, we are a digital talent marketplace that matches employers and business owners to African talent within less than 7 days. When I say digital talent, I mean developers, designers, UI, UX, graphics, digital marketers, digital sales, and brand influencers, and all skills in that nature. So basically, if you are an individual and you have skills in that area, we grow a talent pool where we give resources and enable you have access to these earning opportunities. Whereas if you're an employer, company, or a business owner and you'd like to hire and you do not know where to find this talent, we help you find this talent affordably and within the shortest period of time for you to be able to scale your business. So if you're an employer or business owner, we understand that it is costly, both financially and timely, because of the amount of money it takes and the time for you to be able to replace a role. And that is why we give you value of unburdening you of the entire hiring and recruitment process through intelligently matching you to already vetted quality candidates to provide you 10 times more quality candidates in 1/10 of the time. So our talent pool has been pre-vetted. That means when you come to WAPI to hire digital talent, you're not going to go through the hustle and bustle of going through thousands of CVs for you to find the candidates that you want, but you will only be provided relevant profiles so that you spend less time and less money trying to replace a role. For the tech and creative talent, through the categories that I mentioned, if you're looking for placements or part-time projects where you can put your skills to use, we give you a platform through which you can be able to access these earning opportunities. I've met a couple of law students here that have engaged me on how they're also very interested in technology, and some of them are actually pursuing programming and learning certain programming languages. So if you could probably take on a project and help add value to someone's business while you are still pursuing your studies, WAPI is the place to go. So I would advise you to join the WAPI community. So as an employer or business owner, we urge you that if you're looking for a placement, WAPI is the place to go. If you need to hire web and application designers, graphics designers, UI, UX, digital marketers, technical writers for your website content, digital sales associates or brand influencers, you can reach out to us today at hello@wapi.io and we shall be able to assist you. If you are a digital talent and you're looking for a community where you can find access to earning opportunities, but also other resources that will support you on your journey as you take on these different digital skills, you can still reach out to us or reach out to our marketing personnel over there and you will join our community. Another important arm of our business, which is actually the reason we are partnering with CTDRU, is WAPI events. So what we do at WAPI events is that we enable businesses and corporate bodies to have virtual and hybrid events by customizing for you a platform where you're able to register participants, have the whole program lineup on a platform that is customized and set aside for your event. So you're able to live stream the event, which is what we are doing with CTDRU today, live stream the event on the platform, keep the content of the event even after the event has, is done. You can have resources from the event, for example, the facts. I think that was my favorite thing from the Moot. You can keep the resources of the facts on the event and you can access them even it's been done. And we've worked with others in Uganda that include KTA, NITA, CTDRU today and a bunch of others. So if you're a business, corporate body and you're looking for a digital way to run your virtual or hybrid event, WAPI Events is the way to go. Feel free to reach out to either me or any of our team members, or you can simply reach out to us on our number right over there, or email us at hello@wapi.io. Thank you very much for this platform, and have a blessed evening.
Thank you, Natasha. I'll invite again Mr. Dawoodi from CTDRU to do the awards.
The first certificate of participation in the inaugural Technology Law Moot Court competition goes to Murisa Confidence. Guys, please give Confidence a round of applause. The second certificate for Best Overall Oralist Student in the inaugural Tech Law Moot Court Competition 2022 goes to Mariam Lawoko. But you guys, you clap like you're jealous. Please clap for that girl. I think Mariam is not around. The next certificate goes to Naiga Tracy for the best oralist female student in the inaugural Take Law Moot Court Competition 2022. The third, the fifth, the fourth, I don't remember, but the next certificate goes to Dalton Kisule for the best oralist male student in the Take Law Moot Court Competition. The next certificate goes to Sahid this name is very complicated. Abdiaziz, yes, for participation in the inaugural Take Law Moot Court Competition. For participation. Oh, okay. All right. I've just received information that for participation, due to the number, the coaches are going to receive the certificates. So I'm going to move on to the next. Just a minute.
These are participants. Let's just try to save out.
Mr. Daudi. Where's Daudi?
Okay, so there's just one more overall certificate. We're going to wait for Daudi to come back. As we do that, we'll probably have remarks from okay, I've been told the chief abdicator is not around, so we'll just move on to having a group picture by the winning team, which is Makere in this case. No. Please don't go yet. There's still certificates to give out. Has the winning team left?
Information reaching me is that Mr. Daudi had an emergency, so we're just going to give out the certificate to the best overall written submission to Makere University. I think they had moved out. Their team coach is around, yes.
So Makere it is again. Overall written. Please clap for them.
For the certificates, I think this is all. And all we can say at this point is the rest of the certificates are going to be given to the coaches. Some are pending signatures from the event sponsors and organizers. At this point, without wasting any of your time, we would like to thank you all for attending the inaugural Take Law Moot Court competition, the first of its kind. I know the past 2 days have really been long, they have been heavy. You guys have really worked hard, you read hard, you gave us brilliant and wonderful submissions, and we truly appreciate. To our adjudicators, we would like to appreciate you. I still see that some of you are still here. And on that note, unless my co-MC has anything to say, we truly thank you for attending. We truly thank you for participating. We thank our sponsors, we thank our partners, and I think this marks the end of the inaugural Tech Law Moot Court competition. If you could give yourselves a round of applause for making it through the 2 days. But you guys, you don't even want to clap for yourselves.
They're
Please
still
clap
hungry.
for yourselves.
So we'll take a group picture, and I think that will take place down. Or, yeah, at the photo booth downstairs. So thank you for coming. Feel free to stay and indulge. Others, you can go down, take your section.
To be the best.